And I am showing a time of 9 a.m. Welcome to today's Planning Commission meeting of June 12th, 2025. And I call the meeting to order at 9 a.m. And can we please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And seeing as there was no legal notices for this meeting, we will skip that one and move on to our consent agenda. I am looking for approval of the minutes from May 22nd, 2025 Planning Commission meeting.
I move to approve the minutes.
Second.
Motion and a second. The consent agenda passes. And before we hit our first time item, we do have public input where anyone from the public can speak into any item that is not in today's agenda. And you'll have 3 minutes to speak. Please state your first and last name for the record.
Good morning, Tom Lasik. It's not about what's in the agenda, but the agenda itself. I am respectfully requesting that the commission consider deferring this agenda item to a date and time uncertain. In March 18th, the board, and I've sent comments, so you should have a copy. The board had requested seeing this first before it went to the Ag Advisory Council and the Planning Commission. That has not happened. It's my understanding they had planned to review it in late May or June, but that got pushed, and I think this should have been shifted accordingly. I'm assuming it's an administrative issue, but that being said, the other issue is that there are public comments, not for this meeting, but for the task force that have been compiled from non-cannabis public members that have yet to have been included in the package as it should have been. Those were compiled in November. They were assured they'd be discussed in the task force. They weren't. In January 14th, this came up again. They were assured they would be discussed and incorporated in the remaining task force meetings. Unfortunately, we really didn't have any more task force meetings. Task force was disbanded March 18th. When it was disbanded, this came up again, and they were supposed to be included as part of the overall conversation. To have them just as an addendum and not part of the official attachment, my concern is it wouldn't allow the same level of back and forth discourse from the commission to ask questions of the people of the community, and we'd be limited to only 3 minutes. And that's simply not enough. So my final, just to close, my recommendation is to please continue this so that the board can see it as they requested. If that's not possible, to allow that package to be afforded the same amount of equal time as whatever CDD is about to present, so allow you as a commission to have the same dialogue. If that's not something you're interested in, and or ask CDD as one of your findings to include everything that's in that finding and let the board deal with it. Or let CDD give them 3 minutes like the rest of the public has and see how it feels to be on the other side of that conversation. They've waited years to be heard over and over and over again. It keeps being so, yeah, we'll take care of it. It never gets taken care of. This was included in the package only because we pointed out that time and again it hasn't been done. So that's my comment. Thank you.
Thank you.
Are we in general public comment now?
Okay. Good morning, Chair Chavez, Commissioners, Margot Cambara. I'm speaking on a point of order. This agenda item 7A, should be continued. A continuation does not deny the Planning Commission the opportunity to comment and make recommendations on the cannabis ordinance recommendations. CDD should present its summary to the Board of Supervisors before presenting to the Lake County Agricultural Advisory Committee and to your Planning Commission as the Board of Supervisors instructed. Community Development Department, CDD, is presenting on the topic, consideration of summary of cannabis policy recommendations and requests for Planning Commission recommendation or recommendations without addressing concerns identified by the public.
Excuse me. The comments so far have been about the agenda items that we are going to be reviewing. We will have public input for those items when the item comes up. So basically, this time for public input is for any item that's not on today's agenda.
Right.
Yeah.
My point is that this is a point of order that I'm requesting that your commission continue this agenda item 7A.
No, I appreciate the comment, but that comment could also be made during the public input for the item itself.
But that would occur after presentation, correct? Would you open it to right before the agenda item opens, or would public comment occur after CDD presents?
It would be after the presentation, yeah.
Oh, well, that kind of defeats my point of order comment.
Yeah, but public input for the beginning of the meeting is for anything that's not on the agenda. So
I
Yeah.
understand. Thank you.
thank you. All right. Do we have anybody else in the chambers that would like to speak, or on the Zoom room?
None in the Zoom room, sorry.
Nothing on Zoom.
No Zoom.
Okay. And I do have a time of 9:07, so we can proceed with our first timed item. I don't see a time on it.
There's no time.
Non-timed? Oh, I see. Sorry. No timed items for today's agenda. So we will move on to non-timed items, which is our 7A, consideration of summary of cannabis policy recommendations and request for Planning Commission's recommendations.
Good morning. Mireya Turner, Community Development Director. What you have before you today is a summary of the recommendations made by the Cannabis Ordinance Task Force, as well as some additional recommendations that are from staff, but were not put before the task force for their consideration. In March 18th, or on the board meeting that requested the summary, there was a robust discussion regarding the draft ordinance and the cannabis summary, and the board did request a summary prior to staff starting to work on drafting the ordinance, because they wanted to provide their direction before we spent all the time writing it into an ordinance format. And so that is what we're doing today. Because it serves the best interests of the board to have the Planning Commission's recommendations so they can consider all of these items in a more efficient manner prior to drafting the ordinance. That's why this item is before you today. The recommendations that are received from the Planning Commission today will be added to this exact summary with the modifications to direct it to the Board of Supervisors, so that the board can consider not just the task force recommendations, but the Planning Commission input on that. After receiving board direction on the cannabis summary, which I think is going to take place probably the first early meetings in July, staff will start working on drafting that ordinance. And the ordinance will follow the usual process. Because there are items pertaining to agriculture, it will go to the Ag Advisory Committee. And then it will go to the Planning Commission and the board in notice public hearings. That's after it goes through agency and stakeholder review and environmental analysis. So it's a pretty normal process. Attachments 1 and 2 in this staff report are recommendations from the task force that have previously been considered by the Planning Commission and the board. And so what I'm going to focus on mostly is the recommendations that happened in the last couple meetings before the task force was disbanded, as well as the staff recommendations. What I'm looking for from the Planning Commission today is any recommendations you may care to make on those later items, or if you'd like to revisit some of the items that have already come before you and the board, feel free to do so. This is your chance to add your input to go to the board.
Question. Just a quick question. As you go through this, would you like us to interrupt you at certain points, or do we?
Oh, sure, just jump in. Yeah. I can pivot real quick. No problem. So let's start with the, actually, I'd like to take you back since the Planning Commission, not necessarily our current commissioners, did consider the second update. I just wanted to sort of highlight a couple of the things that came out of the board's consideration of that same update, just to sort of bring it back around for you guys. There was discussion regarding temporary use of recreational vehicles, which is something that we have been encountering in our annual site monitoring visits, and the board expressed concern about that. So we are looking at our normal or our existing code for requirements for farm worker housing, which does allow for RVs. And so we're looking at, because cannabis is considered an agricultural product, the cultivators do have the option for farm worker housing for zoning permits, but we would not, we would hold them still to the guidelines and standards of that. And I'll leave it to the chair to call on you. I don't want to usurp the chair's authority.
My understanding is that that's regulated by the state, farm worker housing.
It is indeed. We also do have zoning permits to ensure that some county standards are adhered to, as well as basic health and safety standards.
Okay, so these people would have to get a state permit?
Mm-hmm.
Like
It's same
housing?
regulations as
Okay.
any other agricultural developer.
Okay, thanks.
Certainly. The next bullet point was to synchronize the measurement of canopy with the state process. This is something we have also encountered on the ground during annual site visits. Is that we go out expecting to see something that is in our site plan that was approved, but we see something that's been expanded. And through subsequent conversations, both with our permittees and the state pivoted in the way that they measure their canopy. So we're going to update. We would like to update so that we're synchronized. This is consistent with board direction to synchronize and streamline with state regulations, so we're not causing repeat or duplicative actions by our permittees. And so that's why the board recommended that. They also discussed adding a requirement of passing the background check by property owners for cultivation permits, as well as adding a step in the completeness review of an application to see if there are any active warrants out, not necessarily leading to convictions, but just active warrants on any of the applicants. And if so, if active warrants were found, that would cause a pause or a suspension in that application. It would be set aside until it was decided one way or the other regarding the qualifications of those applicants to participate in cannabis-related permits. They discussed the lengthy process they went through originally to establish the boundaries of farmland protection zone, and gave staff direction that they are not interested in modifications of the farmland protection zone boundaries nor the regulations. Adding a
Could
Go
you
ahead.
explain the implications of that?
Certainly. The task force had, over a number of meetings, made recommended changes to the, right now, the farmland protection zone has definite boundaries of where it applies. The task force recommendation was to change that from a boundary specific to a type of soil, of the class 4 soils, as well as I think a few additional ones, which would have significantly increased the territory that would have been included in the farmland protection zone regulations, which is prohibiting outdoor cultivation, requiring cultivation in greenhouses. The board expressed its lack of support for that recommendation.
I'm sorry, may I ask a question? Is there a map or something? I couldn't find that as far as a map that actually indicates exactly what those boundary specifics are.
Yes, there is a map that is attached to that resolution. Which, should the Planning Commission request it, we can furnish that. Actually, let's send out a request to staff who is watching. They can probably produce that document. We'll get that down here for you.
Oh, that'd be wonderful. Thank you.
Additionally, I just wanted to also introduce our resource planner, Michelle Iris, and senior planner, Mary Claybon. They have both been extremely helpful and supportive during this process, and they're here also to jump in if I get something wrong, or if there is a question that would be better answered by them.
Thank you.
Certainly. Adding a restoration bond to the abatement of greenhouses for abandoned use permits is a priority of the board. The board also, yes.
Can I just ask a question on the, these bonds? What is the determination of the size of the bond, or is it all just a standard? The bond has to be XYZ, or depending on, say, how many greenhouses they have, or the setup of the particular request? How is that determined?
The board did not give specifics on that. There have been discussions at the task force regarding mirroring state bond limits. And so that's probably where staff's going to start with in the draft ordinance.
Thank you.
Additionally, it is a priority of the board to preserve prime ag soils. So they wanted to discourage concrete slab foundations for greenhouses, instead using the anchor points where feasible to minimize that permanent impact on agricultural soils.
And I have a question in regard to that. I did participate or listened into the task force meetings around the discussion of hoop houses and greenhouses, and quite frankly, I was kind of left unsure of exactly where we stand in regard to both the requirements from CAL FIRE or from State Fire and the building department here with the county of exactly what the requirements are for a greenhouse structure.
Thank you. Mary, would you like to take that one?
Good morning, Commissioners. Am I on? Mic check.
Are you on?
Mic check.
I don't think you're on.
Oh, there we are. Good morning, Commissioners. Mary Claybon. The greenhouse structures are permanent engineered structures. These are anticipated to remain on site for the duration of the use permit. Hoop houses, however, are temporary in nature and can only be applied for and utilized for up to 180 days. They're applied for with a demolition permit. Following the use of those temporary structures, a building inspector will come out and confirm demolition of that structure for the season.
Question. So do hoop houses have air filtration systems?
No. Hoop houses are not equipped with any electrical mechanical systems. They're for crop cover only and can be utilized in light deprivation techniques, but there are no electrical installations within hoop houses. Electrical installations are, however, within the permanent greenhouse structures, especially within the farmland protection zone where they're required to have odor filtration equipment.
That was my next question.
So I have a question. When it says on here, discourage concrete slabs, you know, that's not very strong language. I mean, we either are supporting it and it's okay if it's applied for and approved, or we're saying we do not support that, and we just, if we want to have indoor, it's got to be a hoop house. So, you know, my concern is the language. It's very, you know, besides the other comments,
And,
very wobbly.
So with
yeah,
that,
and quickly to add to that, I mean, my question had to do with the greenhouses. What is the foundation that is required for a permanent structured
sure.
building?
So I'm getting multiple questions at once, so
Yes.
just give me 1 second to go through those. To clarify, hoop houses and greenhouses do not support indoor cultivation. Indoor is in a permanent structure, like a metal building or something that's not necessarily for light deprivation or for mixed light cultivation. Indoor is utilizing artificial light only. The mixed light component of growing inside of permanent greenhouse structures is to allow for some natural light with some supplemental light as well. So that's the difference. With hoop houses, that is no artificial light incorporated, so it's considered technically outdoor cultivation within temporary structures.
Aside from that process, though, greenhouses do not require slab foundations. They're able to be posted on
Anchor point foundation, which would tie the corners of the structure down to the earth to anchor point it to lessen any impacts of a concrete slab being poured as a foundation, rather than the anchor point that would have a lesser impact on the land.
So
They would
just
still
point
go
of-
through the engineering to make sure it's not going to blow over in a storm, too.
So just point of clarification, so when we see greenhouses, there will not be a cement foundation.
There currently is the option for slab foundation or anchor point. However, with recommendations, anchor point does seem to be the preferred mechanism, and that is something that the Community Development Department is supporting to protect the farmland.
Okay, so it kind of goes back to my question of, you know, when we get a demolition bond, that, you know, very different to take down a hoop house as opposed to a structure with a cement foundation.
Yes, that's correct. A demolition for a concrete slab would be more extensive than removing hoop houses that do not have that permanent infrastructure.
So at this point, the support is for the tie-down structure.
Anchor points.
Thank you. Anchor
But
point.
the cement pads are not prohibited, they're just discouraged.
Yes, Commissioner Fields, that's correct.
I'd like stronger wording. You discouraged, either we're okay with it or we're not. I think that just needs to be looked at.
Which
how
is
it's
definitely
presented.
the purpose of today's item. Should there be commission consensus on strengthening that language, that is a recommendation that would be carried forward to the board for their consideration.
Okay, so are we looking for formal motions here, or should we just opine?
Formal motions or consensus would work for us. And I will leave it up to the chair to decide if you want to go item by item for recommendations or save it all to the end.
Would it be better if we go item by item so we can, because I think we might forget some of them?
Yeah.
Yeah.
Otherwise, we won't remember.
Yeah.
It looks like, sure, before, of course, I'll leave it up to the chair for public input on item by item as well, prior to
That's the point of
action
order
by
I
the
was
commission.
going to ask.
I think after we come up with a recommendation, I think we should open up to the public to, if they have anything else to add that could potentially
Commissioners?
help. Make
It is an item before you, so you would need to open it for public comment. That would be a requirement. You may have consensus on recommendations and changes, and you may also have a motion to recommend all of those changes at once at the end to the board, if that works, if the chair would agree.
I'm just thinking of what could go a little smoother if save public input to the end after the recommendations.
I can record what, where I'm seeing consensus on head nods and read it back to you before we go into public input, if that's helpful.
Okay.
Okay. So right now, I'm getting head nods on stronger language regarding discouraging the slab foundations.
Well, I have a comment on that. I think it is, well, since it says discouraged, as staff said, most people choose to go through the anchor points because I'm assuming it's a lot cheaper instead of pouring an entire concrete slab, engineering-wise and everything else. But I think it would depend project by project. That option, if it's, depending on how the soil is, where the slab is going to be poured, where the house is going to be at, I think that option should still be available in the case of an extreme, case where it is required. And then, if not, then that whole project might have to move to a different area that could have more impact. So that's only my take in leaving it as it is. But I did appreciate everyone else's comments on that.
So I agree with what you are saying, Chair, in the sense of, I think it also depends on the size of the property and the percentage of the land that is being affected by a slab. So I think there are some considerations when I think about just agriculture as a whole. If a different ag operation other than cannabis, or a combination of, a variety of different products on a particular parcel, again, depending on the size, a certain percentage of that can have buildings with a slab. So as long as it doesn't, what's the word I'm looking for? Kind of overtake, the prime purpose of the property. So to that extent, I agree with you. I think that in some cases it is a case-by-case matter. So.
And also, like if the soil is not strong enough to support the anchor points, that could be the option that they could use in the case that that a slab is required and they can't use the other one.
I've been just sitting here thinking about how to have a robust discussion about this in the most productive way. And I just want to express that I feel like if a member of the public has something to say about any particular item, that we should let them speak. Because I don't want to get to the end and have to go back. So do what you will, Chair. I respect it, but I just wanted to express that.
Yeah, I think we can do that. Yeah, that's fine.
Yeah.
So, in regards to this specific item,
What I am hearing from the commission is that there should be stronger language to encourage anchor points versus a concrete slab, and only use or use a concrete slab when it won't take away from prime ag soils, and or when anchor points are not an option. I kind of made up that prime ag soil thing, so, but I'm seeing nods. Okay.
So we can take public input?
yeah, so we'll take public input for this specific
Specific item.
or
talking
recommendation.
About greenhouses.
Yes. So the one that says make no changes to the, was it that one? Oh yeah, discourage concrete slab foundations in greenhouses, utilizing anchor point when feasible. Just that specific item, or bullet point, sorry.
Thank you, Chair. Yes, specific to that item,
First and last name?
oh, Tom Lasik again. So this came up in some robust conversation in the Cannabis Ordinance Task Force in the context of farmland protection zones, because they currently don't allow hoop houses in farmland protection zones. There was a desire to have hoop houses in farmland protection zones because of the argument that, well, greenhouses require slabs. It's now been determined that that's not necessarily the case. There are other options. I would encourage the commission to consider that there really does need to be, no longer really needs to be an argument for hoop houses in farmland protection zones, since there is technology that generally supports a greenhouse solution that doesn't use a slab. Thank you.
Thank you for your comment.
Bill Wilson. In regards to greenhouses and versus hoop houses, I would like to get some clarification. Is a greenhouse considered a structure that is not opaque, that is solid, lights only? That's what you say a greenhouse is? It can't be plastic covered on a foundation?
We do have a
And as
definition.
far as slabs are concerned, on farm protected land, most farms have shops, buildings, repair, they're all slabs. I can't see the difference between a slab on a greenhouse and a slab on an equipment shop or buildings or housing. But again, the clarification is a greenhouse not supposed to have plastic?
I think you're asking about transparency, right?
Transparency, correct, yes. You said if it's for artificial light only, or mixed light would be like the hoop house is where you have transparency. So a transparent structure on a slab, is that considered a greenhouse or is that a hoop house?
Just a point of order, just for my own information here. Is the public directing questions to the chair or to staff?
Chair.
To the chair, and then we can pass it over to staff.
Yeah, so comments during public comment period, it's not a conversation. So it isn't a back and forth with the commenters. A commenter can express a question. If the commission wishes to have an answer to that question, then the commission will ask staff for clarification.
Thank you. I needed that clarification. I thought it would be good for all of us.
Yeah, so staff, if you could go over the three different types.
Actually, I can give you the definition out of Article 27.
Okay.
For a greenhouse, specific to cannabis, is an outdoor structure, heated or unheated, constructed primarily of glass, 6 millimeter film, polycarbonate, or other rigid translucent material, which is devoted to the cultivation of cannabis.
I think he was asking about greenhouses, and that's hoop houses, right?
That is the definition of greenhouse in Article 27.
All right. And I guess moving on to the next
Next.
bullet point.
Certainly. The board directed staff to seek additional options to mitigate odor impacts to residential uses. There were a couple more meetings for the task force before they disbanded, and that resulted in a few additional recommendations. Operational hours, delivery hours, and construction hours. The task force recommendation was, let's align this with other ongoing agricultural operations, as well as any state regulations, but limit scheduled deliveries to 7 a.m. to 7 p.m. Records retention, again, align with state, local, and federal regulations. Voluntary, oh, go ahead.
May I have one quick question on that? 7 to 7 p.m., is that 7 days a week?
Yes.
Okay, thank you.
Voluntary termination of a use permit. Now, this was a good one. We've been talking about this in the staff for a couple years now. Our current ordinance does not allow for voluntary termination of a use permit. The use permit follows the land, and it either expires out of non-use, or it has a certain term of life, such as our cannabis use permits, or it goes through a revocation process. So the task force discussed this option, and they would like us to establish a system that would enable a permittee to formally withdraw their permit and end that permit. The conflicts or the issues that we have seen is where a permittee and a property owner may part ways, and that permittee doesn't want their business operation to continue at that location. However, if that permittee were to leave, the property owner at this point would still have the option to convert that use permit over to a different permittee or permit holder. And so it gives a few details on that as far as staff making sure that we have the proper authorization from that permittee, that the withdrawal or the termination of that use permit is not done outside of that permittee's understanding. All fees must be paid and the site must be remediated.
Can you define what that means, site remediation?
Restored to its either original state or a state that is, this is still nebulous, we're still working it out, but it could also be a state that is acceptable to the property owner. Maybe there's a structure there that the property owner would like to keep. So that's still needs to be worked out in details.
Okay, further definition then.
Correct.
Okay.
Or, for example, if that is the case where the property owner and applicant decide to go part ways, since the application goes with the property, if the site remediation would be, how could I say this, like to what the permit is allowed for the whatever permit they had applied, if it's 1 acre, 2 acres, whatever it might be, if any infrastructure that can be reused that still fits that specific site plan, would that be considered, or?
That's a very good question. What I think I hear you asking is, would any existing assets or infrastructure improvements be allowed to stay that are specific to that use permit? That is normally, we do not allow building permits or things like that to take place that would not normally be allowed. Okay, wait, let me start over. Let's say you got a use permit for a cannabis permit and you want to build your 2,000 square foot drying facility before you get your permit approved. We don't allow that. We do not allow any permits to be issued for things that require a use that is still pending. So we'd have to take that into consideration. Would this leftover structure or improvements be allowed without the existing use permit? You're asking a really good question that we have not thought about yet. So I appreciate that. We're going to need to give that some thought.
So, and then I have a question also, and this is just terminology as far as on the, how it's written here. The opening sentence to this topic that we're discussing now says at any point following approval and before expiration date. And then under item A, it says indicating their decision to cease pursuing the permitted commercial cannabis use.
Oh, that's kind of confusing, huh? Because it
Yes.
sounds like they're still applying.
Right.
Yeah, no, this would not be for applications in process. The applicant is welcome or has the authority to withdraw that application at any time. This is only for after issuance of use permit.
Okay,
Okay.
thank you. Thank you for that clarification.
Thanks. Use of recreational vehicles, that was revisited since the board sort of did a 180 or did not support the task force recommendation. And so the discussion was how we have current regulations that oversee farm labor quarters where RVs are allowed. But they'd still be subjected to the health and safety standards. Opt-out or reduced canopy process. So this started as an internal policy. It's not really covered in our ordinance. But it started because the service or the option was offered at the state level, and so we were kind of mirroring the state. And it allowed for flexibility of our permittees to not be bound by cultivating the entire amount that was allowed. They could opt out that year and not cultivate at all, in which case their taxes would be waived or minimized in a reduced canopy. We would like to formalize this program and limit it as well. Some of the things that are seen not just in this jurisdiction but statewide Our sometimes opt-outs end up still with cannabis entering the market, which doesn't make any sense except that it's avoiding taxation. So we'd like to sort of tighten that up and allow for to align with the state regulations. The June 1st deadline that the board approved as an internal policy is working really well as far as allowing staff to see what we're looking at as far as this year's harvest. It affects our site visits. And so that June 1st deadline we'd like to codify, as well as probably only allow a certain number of opt-outs during the 10-year permit process.
So when they say opt out, they just say we're not cultivating this year,
Yes.
but they end up doing it anyways, or?
There have been, in discussions with the treasurer tax collector, that's what they're finding throughout the state. Not necessarily all of our permittees, but that they are finding that there's still cannabis products entering the metric system, but they opted out locally. So this is just an effort to sort of streamline internally our processes and make sure that the proper tax is being assessed for what is actually getting grown. And it looks like Mary might have something to add on that one.
Yes, thank you. I would like to add that any project that is approved for mixed light or indoor cultivation that does opt out of cultivation for the calendar year is required to have a site visit during annual inspections, because we cannot confirm that there's nothing inside of those structures without being on site. So outdoor cultivation operations do have the ability for us to use GIS technology and also drones with property owner approval. However, those mixed light and indoor operations where cultivation is occurring within structures do require our staff to go to the site visit, boots on the ground, eyes on the site.
And are those unannounced visits?
No, these are pre-scheduled visits. That way we can be sure that there's a representative on site. As you know, there are very strict security measures, and all of these sites are locked. So we need to gain access and entry, so we do have them scheduled.
And also, around what time would these, because you say annually, so at the moment that they opt out, you schedule that, a couple months down the line, usually when cultivation happens? Because I know that one's like more controlled, right? So you could do it year round?
Sure. So with our annual inspections, we do conduct those during the growing season, so we can see these operations actually operating. We want to make sure that there's plants there, and with that each plant is tagged, all of the basic requirements. But we also want to make sure that if there is an opt-out, that there's structures for that we're able to see that during the growing season as well, to kind of circumvent cannabis that's permitted cannabis entering a market illegally if it's, being either grown and then not placed into the metric system, or whether it's not being grown at all, and we've identified that, and we can share that information with the tax collector's office.
And also, for example, like let's say, I don't know how many indoor facilities we have here in Lake County, and how many have opt out since we've been doing this. But something that I know the city of Clear Lake does is that whenever there's a vacant commercial property, you're required to do, I think first it starts as monthly. You have to send pictures, a report of what's inside. And then if you're a compliant, property owner, then it switches to quarterly. And then eventually, I think it stops at quarterly, so you need at least 4 reports a year. Is that something that you guys would be willing to do for any of those? Because I know that, you have to be there at the time when cultivation is happening, or, just an observation, I guess.
So we have one project that's approved for indoor cultivation. With that, the structure has not been completely constructed in which those activities are going to occur. There is an amendment to the use permit to allow additional structures for indoor, but at this time that is not a concern for us for our indoor operations because we only have one project that does fit that mark. If there are any indications or concerns from the general public, those concerns can be channeled through our code enforcement division, who will then send officers to respond. They will come to the area. They look for identifiers such as smell, garbage waste, any lights that may be indicative of cultivation inside of structures, those types of things. So we would have our cannabis code enforcement division follow up on those types of requests. But from the planning division, our annual inspections are annual.
Thank you. Any more from the commission before I pass it on to the public? All right, I see some hands, so state your first and last name.
Good morning, Tom Lasik. On the opt-outs, the conversation I think has been really good, and I think it does need to be reformed. I know of a couple growers myself that feel frankly trapped on, not on the opt-out, but on the being able to gracefully get out of the business, let's say, and being able to do that voluntarily, I think would be very helpful for those that realize it's, cannabis cultivation just isn't for them. So a way to do that gracefully should be incorporated. On the opt-outs, I think the idea is good to have a limit first for a grower to opt out like every year. It's not using a term that the industry likes to use. It's not the highest and best use of the land to keep it vacant. So there should be a limit to that. Fees being paid is a good idea, but I would extend that to also taxes. In discussions with Treasurer Sullivan, there are a disproportionate amount of the properties where cannabis is grown aren't paying their property taxes. So they should, before they're allowed to have this, there should be some mechanism to make sure not only are the cannabis taxes paid and the fees paid, but the property taxes are paid. It might be an incentive also that, the first time you opt out, that's fine. The second time you opt out, it encourage them to either, voluntarily get out of the business or pay a portion of their cultivation tax that they would have paid if they were cultivating. Something to bring more revenue back into the county and also just make administration a lot simpler so you don't have to keep doing the same thing over and over and over for the same people. So thank you.
Thank you.
Bill Wilson, on the opt-out policy, I think that's a good policy, but I was wondering, does the county have the staffing to do several inspections per year? If you have a greenhouse and you get 4 crops a year and they opt out on June, are you going to check every 3 or 4 months, whenever, to be sure that something isn't being grown? And the other thing on the code enforcement, when you mentioned the CDD or code enforcement will come out and react, and I have been told from the previous cannabis director that no, they won't come out if I'm only the one complaining, or the code enforcement, Linda Rosa, said no, she won't come out if I'm the only one complaining. So no, they do not respond if we have concerns about smell or light or anything like that. Thank you.
Staff, if you would like to clarify any of those questions, or if there is any answers to those.
Is there a particular?
There was 2 questions, I believe, right?
My question would be, is it up to code enforcement to decide when to go out, or is it written somewhere?
We do annual site monitoring visits. It does place a significant burden on staff to do so, and so we do it once a year. We do not have the staff capacity to do it 4 times a year. We do respond to complaints, so aside from our annual site monitoring visit, if we receive a complaint that causes concern, we will respond to that complaint.
So I understand that your department responds to the complaint, but is there some way we can write it into this that code enforcement must respond to every complaint?
I don't think you would receive department or board support on that one, but you if that's a recommendation of the commission, we do not have a requirement, actually. We do use our discretion. We have actually worked a lot with Mr. Wilson responding to his complaints as they come up, because we don't just take them lightly. We do take them seriously.
I think the more global question is the response to just one person's concerns, or does there need to be 3 people that have the same
I am not aware of a policy that says it must be more than one complaint. We evaluate the complaints as they come in. Sometimes it takes a while for us to get to them because they may be placed lower down on the priority list when we're dealing with houses with rats running to the neighbors, or other things of higher priority in the health and safety issues. But we do consider complaints as they come in. Sometimes they're not handled by code enforcement. Sometimes they're better dealt with by planning. And so we do that sort of deferring or farming out as needed and as appropriate.
I'm just concerned because I'm familiar with Mr. Wilson's situation, and he's the only neighbor right there. There's a worm farm or something across the street that has its own odor that's not regulated, but...
Replies to Mr. Wilson regarding it takes more than one complainant for us to pay attention is not consistent with current policy.
I think I understood that it was code enforcement that was saying that, not your department. So I'm not...
The employee that he referred to is no longer with our department. I am not aware of code enforcement having any policy that says it takes more than one complaint for us to pay attention.
Okay.
And in fact, that's not consistent with what I have seen us do in the 2 years that I have been here.
Bill Wilson, it seems I come across in chapter 27, it said to be a nuisance complaint, it has to be numerous persons or neighborhoods. That's what it was written in the ordinance. Thank you.
That is not consistent with what I have seen take place in our department in the 2 years that I have been here.
So is that currently written in the cannabis ordinance?
Mm-mm.
I'm
He was
asking for the
referring to a different chapter.
a chapter of,
Chapter 27 in, I don't have that with me now, but I have the emails from the previous cannabis fellow and also from the employee that is no longer there, and it states that it has to be numerous persons or neighborhoods for them to proceed. They both have said we cannot proceed on this because I'm the only person complaining. And I have their emails here, and I don't have I think it was the chapter 27, I'm sorry.
Actually, yeah, the nuisance abatement is covered in chapter 13. So
okay, yeah.
we'll take a look at that. But yeah, we've responded to multiple complaints that just came from Mr. Wilson. So because it's important.
so
Thank you.
I would just hope that we could look at where that is written down, wherever that may be, that there is not a threshold of 7 or 2 or...
If Trish upstairs in planning is listening to this meeting, if you wouldn't mind printing out an excerpt, that would be very helpful.
Yeah, then we can just understand where it comes from.
I can tell you how I see practice, but I appreciate Mr. Wilson citing code, so I could actually be wrong, and it's just not what we do. So.
Yeah, well, let's just take a look.
Okay.
And I would just like to add to
Great.
this.
And our code enforcement manager is also on his way.
Oh, great.
Supervisors? My apologies, commissioners. I've just checked Article 20. Yeah. Just wait until I start referring to you as Your Honor. I have just now checked Chapter 27, and there is not a requirement for numerous complaints that I could find in my quick...
Chapter 13.
Are you checking Chapter 13?
Yeah.
Okay. That was my next stop.
Oh, you've got it? Oh, okay. Yeah,
Okay.
Michelle can read that if the commission wants.
This is chapter 13 of our municipal code. For reference, chapter 27 is our zoning ordinance, so this is a different chapter. It's the nuisance chapter. It says nuisance shall mean any condition declared by statute of the state of California or code of the county of Lake to be a nuisance, or 2, any public nuisance known at common law or equity, 3, any attractive nuisance which may prove dangerous or detrimental to infants, 4, any condition dangerous to human life, unsafe, or detrimental to the public health or safety. There are actually 16 of these, so bear with me or stop me if you'd like me to stop.
Well, I think the issue is not what defines a nuisance,
The number.
but the number of them that is required to get a response from code enforcement.
So we also have our code
Commissioners.
enforcement manager.
If I might make a recommendation, if you're looking at how to create an increased or a distinction for cannabis uses in this case, there is oftentimes an ability, it happens occasionally in our ordinance where the board adopts language that specifically defines a thing as a nuisance, and that takes it out of the nuisance definition. And it makes it automatically a nuisance. So for example, there will be language in some parts of the ordinance outside of Chapter 13 where it may say that when X occurs, that is deemed a nuisance. And then that language would be put in that specific code section, and it would automatically create or make that particular action or occurrence a nuisance that code enforcement could then enforce under Chapter 13. So you might consider recommending language along those lines as far as certain. But in those instances, that particular section would identify specifically what would be a nuisance. Otherwise, the general nuisance ordinance section would apply.
In cases of odor complaints, we have brought together planning and code enforcement, and I think building, didn't it? And when we've gone out to respond to those, because we want to make sure that the permittee is complying with their required air filtration systems and things like that to make sure that they're not violating their conditions of approval. So we've done that to a number of processing locations in Lake County over the last year, 2 years, probably before I got here, but definitely since then.
So what I'm understanding is that we could say that we would or to just codify that all complaints trigger a response from the county, and maybe not even specify which particular.
I think that is existing county policy at this time. We do respond to complaints. Not necessarily does it prompt a site visit, but we do respond to all complaints.
Yeah, I believe that if the Chapter 13 says a certain amount, as Maria has, as Director Turner has said, the response is not limited to having a whole neighborhood. No matter what response comes in, like they're gonna be looking at it regardless. I don't think they're not gonna say, oh, like, oh, we only got one complaint from this area, we're not gonna even reply. I think every input that comes in, they're looking at it regardless. So they're doing more than what Chapter 13 is requiring. So I don't have an issue with this specific item or bullet point.
So
Bill, I'd like to respond. I do have the email here from Andrew Amelong after I had my complaint, and he says, you are the only one affected by this, and therefore it does not constitute a public nuisance. This was his response to me after my complaint. And to also sort of challenge the operation of filtration, I'm not sure who is qualified in the county to go out and say, okay, yes, you have a filter, but if the filter is so far underdone, I mean, if you have one filter that is 15,000 cubic feet capacity and you have 272,000 cubic feet of building, and they have a filter that is qualifying as filter, I mean, that's where I have problems with the county and not having enough staff to check up on all of these permits. If they say they have, and they have air scrubbers that they are not using, because you can see mist when they're using them, and they are not using them when there's a big smell. So who is checking up on that? And who permitted a building with 272,000 cubic feet with one 15,000 cubic foot filter? That got approved, and it says it's the best run place, it's a nice operation, but it's under filtered. So where do we go from there? I complain about that, and I'm one person complaining, and as Andrew said, I'm one person, so it doesn't matter.
What's the date of that email that you received?
Pardon me?
What's the date
The date of the
of the email that you got?
I think it was 2023. I just have September. It just has September 13th, and I think it was 2023, 2022. I can't remember which.
And have you made any recent complaints regarding odor?
Pardon me?
Have you made any recent complaints regarding odor?
I complain, and I don't complain because it doesn't do any good. I've written in and said, okay, can you come out? Linda Rosas, when she was doing it, she says, well, I don't have time right now. So when I'm smelling it and we are run out of our house and our house is filled with odor, and they show up 3 days later and say, well, there is no odor, or the filters are running the way they're supposed to run, and they say they shut them off for 45 minutes. The filter manufacturer says they run 24/7. They're not supposed to be shut off. I mean, nobody, I don't think, is qualified to check what is actually written into property management plans and initial study plans and what is actually happening. That's my concern. Does the county have the staff to check those specifications? Thank you.
Thank you.
Because there is already a recommendation to seek additional options to mitigate odor impacts to residential uses, I think this is included in where the staff will spend additional investigation time.
I don't know if it makes a difference, but I would be willing to make a complaint as well, as I've driven past Mr. Wilson's house recently, and I did detect an odor. I can't tell you when it was. It might have actually been last year, but another issue that I have noticed in another location in Lake County, I didn't feel it was worth complaining about, but every morning at 8 o'clock, I notice that employees enter the building, and that allows air to escape, and it's significant enough that I can smell it 1,500 feet away.
And so if I could ask a question, then, since you seem to be familiar with this property, and this is just a general information I'm just trying to piece together here. With the property, do you know what the property is zoned, and perhaps maybe what the setback is from the project site to Mr. Wilson's?
If the commission would like to agendize a specific permit for discussion, we could do that.
Bill Wilson,
But-
I can tell you, it's, the zoning is considered commercial cannabis cultivation exclusion zone is where we are. We're 800 feet away from the plant. And again, there's lack of filtration, and they have a permit for 12 greenhouses, and there's one greenhouse right now that drives you out of the house. But we're 800 feet away, and it's a commercial cannabis exclusion zone that got permitted for a greenhouse. Thank you.
Yes, but I was asking what the property is zoned
I think Director Turner is probably right on
Yeah,
this. 'Cause
since we're talking more about policy recommendations and not specific use permits,
Correct.
I'd like to bring us, or request that we kind of come back to.
And that's why I didn't really want to, I'm sorry, Mr. Wilson, I wasn't directing this question to you, I was directing it to Miley, because I just wanted for the bigger picture to get an idea as we talk about odor, where are we seeing the problems as we continue to talk about this and make changes.
It's intensive ag with a vineyard.
Excuse me, sir.
Yeah, thank you. So,
I think that probably, since this is very specific, we should have an agendized item that we address as you recommended. Can we do that?
What would the agendized item be to do?
yeah, I'm not asking for that. I was just, again, looking at it in the bigger picture, for the conversation about odor. Just, again, where are we seeing problems, not in specific projects, but, overall in with the cannabis ordinance, where are we seeing problems? And perhaps we need to create a bigger setback. Perhaps there are other things that we need to look at. So that's all I'm trying to.
And the setbacks, in order to minimize, during the board discussion, they were talking about odor impacts of cannabis uses or cannabis-related businesses on residential uses. Right. So additional setbacks were one of the things they mentioned, additional mitigations, things like that. So that's where staff is already going to be looking due to that board direction.
I'd like to second what Monica said. I do think that this is a broad discussion. This is just an example of something that's probably happening in other areas that we're not hearing about.
I'm getting strong commission consensus to seek additional options to mitigate odor impacts to residential uses as listed. Okay. Great.
Commissioner, to answer your question, the commission is not a policing body, so it does not have authority to just bring people who are making use of a use permit before them for questions. Your commission, however, does, under Chapter 21, Article 60, have the authority to, on its own, bring a revocation action if you have evidence to support one of the three findings in Article 60, which are: 1, that such permit was obtained by fraud; 2, that one or more of the terms or conditions upon which such permit was granted has been violated; or 3, that the use for which the permit was granted is so conducted as to be detrimental to the public health, safety, or welfare, or as to be a nuisance. So if you can support that, then you can certainly, the Planning Commission may revoke or modify, so you may bring a use permit before yourselves for that purpose. I would recommend, though, that there be significant evidence in the record to support bringing such an action, and I think so the best course of action in circumstances like this, where during public comment, either general public comment or public comment on an item are brought before you, that you can certainly direct staff to look into it and determine whether or not there is anything to support a revocation.
And that goes to, we haven't gotten there yet, but there is the report, I forget what it's called because we haven't gotten there yet, but there is something in these papers that refers to, as far as the project review coming back before this body. And I would assume, or I look forward to getting to that discussion, because I think that kind of opens it up for us to then be able to identify.
Yeah, I think the issue here is a blending of the difference between a project as an application and a use as an approved use. And the county does not issue licenses, regardless of the language used in the ordinance. We issue use permits. Your commission issues use permits. Use permits have a long-standing history in the law as to what they mean, what they are, and how they function. The same with licenses. The state issues licenses. They are for a specific individual. So that individual has a right in that license. Use permits are not issued to an individual. They are issued and then they attach to the land, which means whomever has the legal right to access that land has the legal right to use that use permit. So in this case, what would be brought before your commission at any given point would be related to the use of that permit. So if there is a misuse of the conditions of that permit, then any permit, not just cannabis, but any use allowed, there are the conditions that allow for that use and under which that use should be engaged. And if those are not followed, then there is a risk that that use permit may be revoked by your commission. The individual is not, while it may impact the individual using the permit, or it may impact the landowner, or both, the individual is not the focus of any of your decisions. It's the use and that as permitted, and the use as engaged in. So that would be your area of authority, would be that. And once it's been issued, it would still have to be within that framework that your commission would review it. You wouldn't be policing an individual in their use of the permit in the sense that whether or not they engaged in a nuisance. Under the nuisance ordinance, we do have sections that make an individual and their use of a land make an individual responsible for their own use of the land, but that is not a section of the ordinance that your commission applies. That is, as noted earlier, that lies within certain other regulatory authority, which would be like code enforcement, specifically code enforcement. But and you occasionally overlap in the sense that the decisions you make and actions you take may involve code enforcement, but that is not your authority here. So what you're looking at under this particular proposal for the ordinance is how the county reviews and approves uses in connection with specific parts of the county itself, right? So that would involve an analysis of the zoning ordinance, local area plans, general health and safety in some respects, but it would not involve the specific regulation of individuals using or engaging in those uses, if that makes sense. I hope that helps a little bit.
Yes, it does.
And I do have some hands in the Zoom room. If there's no further comments from the commission.
Just one. I'd like to suggest that Director Turner review the use of this particular project and bring it before the commission if she feels it's appropriate.
And I'll take some one hand in the Zoom room if there's no further comment.
You have no comment.
We have Janae Freed in the Zoom room.
Janae.
Hi, yes, I work for the Central Valley Regional Water Quality Control Board. I've worked with Mary Claiborne a bunch. I regulate cannabis sites in Lake County. Can you hear me?
Yes, we can hear you.
Okay, excellent. I actually raised my hand during the topic on voluntary terminations. And I just wanted to kind of add a little bit of input from my agency on that topic. As you guys know, there's that moratorium on new applications to Lake County that don't have a notice of applicability from the Water Board dated October 31st, 2020 or prior. And so a ton of cultivators and landowners applied back in 2020 for our program. And some of them ended up applying to the county for use permits. Some of them, maybe they never did. However, the ones that did apply, some were denied, some are still in process, some were approved. And out of those ones that were denied and the ones that were approved and maybe have ceased cultivation since then, they then continue getting invoiced by my department every year. And as I'm sure a lot of you that work in this industry know, there's often a lot of landowner changes and lease changes, cultivator changes, and just general responsible party changes in general and mailing address changes. And so sometimes our invoices don't even get to them for a couple of years. And now these, we call them dischargers, cultivators and landowners in our program. These dischargers are in debt, and we can't erase that debt because our policy is if you were enrolled, you enjoyed the benefits of our enrollment, and we can't revoke those invoices. And so my suggestion / comment is that when cultivators are either denied permits or they expire or they quit payment or they voluntarily terminate or any of those ways where they are no longer permitted with the county or been denied access, if there was a way to either require them to terminate with the water board as well before they voluntarily terminate, or at least send me my department a message of some sort, put me on the CC list for the termination letter, because what ends up happening is these people will say, I haven't had a permit for 3 years with the county, or I was never even approved, and now I've been invoiced for 2-3 years, and I don't cultivate anymore, so I don't have the money to pay this. That is my comment. Thank you.
Thank you for your comment.
One more.
We have one more hand in the Zoom room.
Yes, it's a guest. You can speak now.
Guest, please state your first and last name.
Thank you. My name is Angela Amaral. I wanted to go back to we were discussing the concerns over odor and complaints and that kind of thing. And Commissioner Rosenthal is correct. There are annual reviews that right now in the ordinance state the annual reviews are supposed to go to the Planning Commission on an annual basis. And I think that would be the appropriate time for projects to be reviewed for complaints, general health and safety issues concerning the residents. But since the ordinance has been into place, not one project has gone before the Planning Commission for its annual review. So that's a big problem. We need to get that into the works and start doing that so that these issues can be addressed on a project by project basis. Thank you.
Thank you. We had another hand in the Zoom room.
Nara Darbaka?
Nara, state your first and last name for the record.
She needs to unmute.
Nara,
Sorry. It took a minute for the unmute to pop up.
there we go.
Hi, Nora Dalbaka. I'm currently president of the LCCA, the association that represents cannabis businesses throughout Lake County. I also served on the task force. I actually just have a clarifying question right now. I'm a little confused about public comment. Today, we have a letter that we were planning to have read into the record today during formal public comment, and I don't know if we should wait until the end to do so, or if we should read that now. And then I also did want to let you know that I do see folks in the room answering questions. I did want to let you know that I believe Jennifer Smith, who also served on the Cannabis Task Force, is also here in the Zoom, and we are here available to answer questions if folks have. If any of you commissioners do have questions for us, we're here. We're available to answer these questions. But I'd love to have a little clarification about if there's going to be a formal time to read that letter.
If you would like to read the letter now,
sure, I'm happy to.
and then I'll give. We have a 3-minute limit, so I can give you the 3 minutes.
Smith just run all over the board. It's not right.
All right.
Somebody else?
I can start it perhaps, and then maybe someone in the room can finish it if I'm not able to hit my 3 minutes, since I may have run it down a little right now. Honorable Chair Chavez and Planning Commissioners, the licensed cannabis industry in Lake County, and in fact all of California, is at a crossroads. Despite numerous headwinds, the industry has continued to grow and establish itself as a major economic driver in Lake County, directly supporting hundreds of jobs and millions of dollars in tax revenue each year. In 2023-24, the cannabis industry generated more than $2.6 million in cannabis tax revenue for Lake County. As noted in the recently published California Cannabis Market Outlook commissioned by the Department of Cannabis Control, retail cannabis prices are down and competition from the unlicensed market remains strong, but the industry is growing. This study, which I can submit along with the executive summary, contains recommendations pertinent to this ordinance update. Among other things, the report suggests that as the industry continues to evolve, streamlining local regulations is vital to fostering resilience in our local industry. And I want to share 2 relevant sections from the report. First, it says that the state should encourage local municipalities to lower restrictions, taxes, and fees for cannabis businesses. These are additional costs to cannabis businesses that affect decisions on where to locate and how resilient businesses are to down years in the market. Recent state-level changes have eased the regulatory burden for producers, but local regulations create additional barriers for licensed producers. These barriers to entry create advantages for unlicensed businesses. The report goes on to highlight the importance of lowering regulatory hurdles as a tool to shrink the unlicensed industry. Local taxes, fees, and restrictions increase costs for licensed businesses and can result in an effective local tax rate of more than 30%. Working to lower local restrictions, taxes, and fees for licensed cannabis businesses would support the licensed market. Local costs affect decisions on where to locate and how resilient businesses are to down years. We appreciate the opportunity to engage in this process and want to acknowledge that many of the recommendations put forward by the task force are thoughtful, balanced, and clearly informed by the challenges facing our local industry. Several of these recommendations reflect the very guidance outlined in the state's own cannabis market analysis, namely that lowering local barriers and restrictions is essential to supporting a legal and sustainable market. As a small community of farmers, manufacturers, and local business owners, we know firsthand that further restrictions.
Yeah, I'll let you go because I'm like.
Excuse me, Maria, could you please mute yourself?
Oh, I'm sorry. I'm mute. I don't know how I got unmuted.
All right, Nara, if you would like to continue.
It automatically muted me, I think, when hers unmuted. I'm not sure how that happened. As a small community of farmers, manufacturers, and local business owners, we know firsthand that further restrictions would not only hurt licensed operators, but also strengthen the unregulated market that these policies aim to present. What's needed now is a path forward that supports local jobs, keeps revenue in the county, and helps responsible businesses succeed. We hope that you on the Planning Commission will recognize this moment as an opportunity to reinforce and not restrict the foundations of a legal cannabis economy in Lake County. And a lot of the problems that you're hearing described today are, again, issues with the proliferation of unlicensed grows. And the stronger the licensed market is, the less, the weaker we make the unlicensed market, which is doing the real environmental damage. So environmental and criminal damage to this county. So thank you very much. And again, Jen and I are both, I believe, on the Zoom. If any of you have clarifying questions on as you move on.
Thank you for your comment. I got one more hand in the Zoom room.
Maria Khan.
Maria Khan. Maria Khan, would you still like to comment?
Yes. Can you hear me now?
Yeah, we can hear you.
Oh my gosh, I don't know how I got unmuted. I was just listening. I'm multitasking in the background here. Okay, I just had two comments. I tried to hit the comments before the whole thing started, just to let you know that I had attempted to put something into the Granicus system, and it won't even let me log in. I that's a terrible system. I could not get a comment in there because it kept popping me back to the login screens. So I just want you to know that there's an issue there. The second is, I don't know where this is going to fall, but there was one thing that came up with all these ordinance recommendations, and that is consumption lounges on the properties. And I just want to voice my opposition to them. Living on a road with a winery where people leave in a tipsy state, coming through our valley, we don't need people coming down off the mountain high, adding to that danger. So I just want to say that I'm actually very much against the consumption lounge idea. I don't think we need members of the public coming to these grows to sample the goods. So that's just my comment. Thank you so much. And now I'll unmute myself, or mute myself.
Thank you. All right. Should we pick up where we left off on? Oh, yeah, go ahead. First and last name for the record.
Michael Green. Kind of lost. We're about 20 minutes. I think we were still on odor control, but I want to echo everything County Council said as far as what this body does and doesn't do. And it was very concerning. The reason I first stood up is because I felt we were well off the beaten track. We're here to review recommendations to the ordinance broadly to all applicants and not to litigate somebody's existing complaint. So that was very concerning, and I hope we don't go down that road again. I was heartened to hear the State Water Board show up to this meeting. There's a bullet point that wasn't raised in today's staff report. I think it's an issue. There is, in fact, a de facto moratorium on new applications unless you happen to have one of the Willy Wonka tickets, as I call them. If you pulled a water discharge permit from the State Water Boards for cannabis cultivation prior to that 2020 cutoff date, you are eligible to apply for a permit. If you didn't, you're out of luck. So the effective amount of parcels that are eligible to apply in Lake County is limited by that clause. Elsewhere in the ordinance, there are provisions that make perfect sense. Once you get your use permit, then you have to go get all applicable state permits and what have you, including a grading permit, LSAs from CDFW, what have you. But the way it's written right now, we have a prerequisite. And so I felt for the lady from State Water Boards, oh, if we decide they don't get a permit, can they force them to give up their State Water Board's permit? Well, I can tell you right now, they're not going to give those up because that's the only way they can get a new application in. So there are people who are going into debt. There are people paying thousands of dollars every year to the State Water Board for permits that they can't use because their permit either hasn't been processed yet or they haven't got the ducks in a row to put in an application. So that's not on your bullet point today. I know there was some, I think Director Turner said the board had indicated, brought in support that they want to keep that throttle in there. But what it effectively does is creates a protected business class. It stifles the ability of our industry to scale. It punishes people that weren't didn't have the ability, didn't even know where the permit process was 5 years ago. And there's been any number of struggles, both within the department and elsewhere in the county, trying to figure out how to get these things through. So I just want to make sure that the words notice of applicability from the State Water Resources Control Board as they pertain to cannabis cultivation is at this point a throttle on development. And if we are ever going to scale this industry, removing that as a prerequisite, or at least figuring out how to set opening criteria for a new round of applications, you need to get over that hump somehow. But all these things we're talking about, and the ordinance and stuff like that, understand it's a very finite set of landowners that are going to have any opportunity to take advantage of this ordinance until that changes. Thank you.
Perfect timing. Thank you for your comment. Please state your first and last name for the record.
Good morning, Chair Chavez and Commissioners. My name is Andrew Dabbs Kramer. First, I want to thank staff and the Cannabis Ordinance Task Force. This was a long process to get this here. A lot of thoughtful and challenging conversations occurred to bring these recommendations forward, and I know staff has spent a lot of time doing their research on best practices across the state and try to bring forth the best they can. So thanks to everybody who's been involved thus far. I just wanted to also echo the previous commenter and comment on the NOA situation, because I think that's flying a little bit under the radar here. We're talking about setbacks, we're talking about zoning, we're talking about all these constraints on where these farms can be located, without talking about the largest constraint of all, which is the notice of applicability from the State Water Board. If that was not secured prior to the deadline, then no matter how good the property is, no matter how much the neighbors might like it, it might be appropriate, it's not available to cultivate on. So I think that's a policy decision that's been taken by the board, and that's up to them ultimately. But I think the idea of trying to take NOAs away from folks, or have people's NOAs canceled who might not yet have their permit processed, is just going to create a rush on the few properties that are left, and it's going to artificially exacerbate the problems of location. It's not actually going to be the highest and best cause for this county. I think continuing to understand that people, if they want to pay the NOA fee, if they want to stay enrolled with the state, let them. It allows them to have the flexibility to enroll in the future or to submit a new application. There also might be situations where somebody might have a approved use permit and decide they want to change their style of growing and they need a new use permit, and so they need to withdraw their use permit and submit a new application. They shouldn't lose their NOA in that case because they're trying to change their method of cultivation. So I think the NOAs are really important, and the idea of removing them is really problematic. Thank you.
Thank you for your comment. First and last name.
Tom Lasik. Just back on the conversation about odor. and the concern about you're the only complainer. There is unfortunately, it is a culture that we're noticing, especially here in rural areas, where the decisions are made that, well, there aren't enough people around for it to be a risk. You can see I've poured through probably a dozen different major use permits, particularly in rural areas, and I'll say, well, there's only 2 or 3 families within this distance, so then, it should be fine. That kind of attitude or rationalization pretty much disenfranchises anybody that's in a rural area. I also encourage that the odor issue be looked at. In the case of Mr. Wilson, as an example, he's 800 feet away. If the ordinance was enforced to, say, 1,000 feet, the math works out that it would reduce his impact by over 30%. So it's a exponential relationship, not a linear. So every time you say double the distance, you reduce the impact by a fourth, or to a fourth. So an odor conversation needs to happen. It's one of the biggest complaints. It's something that is a conflict between neighbors that shouldn't have to be there if it's done properly. And as Mr. Wilson has pointed out, the challenge is getting it enforced. We have these ordinances here because we want, one of the reasons we have ordinances is to reduce conflict. We also have health and safety reasons as well. But if those ordinances aren't enforced, it pushes the conflict into the community. We don't want that. Thank you.
Thank you for your comment.
You have one hand.
I'll take Chambers and then I'll take the next hand on Zoom.
Hello, Autumn Carsey, Artemis Kopak. I just wanted to note that when we're discussing the agenda, I think we left off on revocation of permits, and then we've kind of jumped all over to odor and everything else. So I'm having a hard time keeping up with the meeting agenda. So just requesting that we can kind of stick to the agenda bullet points and keep from jumping around. But on the setbacks, odor issues, and having farms conform to further setbacks really does hurt farmers. We're already pushed out into mountainous areas. We're excluded from prime ag soils, and this makes cultivation harder. It's harder to get equipment through these fields. It's harder to compete with, say Desert Hot Springs area or Yolo or any of these counties where they have flat ag land where you can get equipment through it. So it pushes our cost of cultivation through the roof, and it would inhibit farmers from cultivating. Also, the existing permits, how would that affect them if you suddenly double a setback and then the 10-year permit is up? What are those farmers to do if they put millions into those properties and now they can no longer cultivate because they're in violation of a setback that came about after their permit was activated? Thank you.
Thank you. I'm going to take the one hand on Zoom.
Pardon me?
I have a hand on Zoom.
Oh, I'm sorry.
Yep.
Janae Freed, you may speak for 3 minutes.
Oh. And in the Zoom room.
Janae Freed from the Central Valley Water Board again. I just wanted to address what I think 2 of the public commenters had said. I wasn't suggesting that NOAs would be terminated automatically. I was suggesting that the county either notify me or the dischargers that if they do not want to get invoiced by the water board, that they would also need to terminate with the water board. The issue I have is lots of dischargers getting very frustrated with me and my organization for the invoices because they are no longer in the cannabis industry. Thank you. Thank you.
So we're going to take a quick 5-minute, 10-minute break. We'll do a 10-minute break. So it's 10:32. We will be back at 10:42. Thank you. Check, check, check. And welcome back, everyone. We will begin the meeting. It is 10:42 after our 10-minute break. So welcome back. And yeah, I'd just like to continue where we left off. I do know that there was...
Certainly.
Yeah,
I think we
Director.
stopped at opt-out and reduced canopy. Did we cover the site reclamation bond? I don't think so.
Not yet.
Okay.
Were we going to have at some later time a global conversation about global issues around odor?
Yes.
Okay.
Part of the one bullet point, seeking additional options to mitigate odor impacts to residential uses, that will necessitate a global conversation on that topic.
Thank you.
My pleasure. Site reclamation bond. The Planning Commission, or no, sorry, Task Force recommended a $5,000 surety bond because this mirrors the requirement at the state level. That is for site reclamation. They went on to list the It is? That just doesn't look like English. Okay, yeah. Be the Community Development Department. Then the canopy calculation method, they supported the recommendation to synchronize with the state.
I have a question on the reclamation bond. $5,000 is not very much to go through and return a property to its original status. So it seems low.
There was discussion at the task force meeting regarding that is what is available for the cannabis industry at this time amongst the bond seller people.
So we couldn't require a $20,000 bond, or say, for instance.
Should the Planning Commission make a recommendation that staff investigate that item for a higher amount, we'd be happy to do so.
I would like to recommend that, because $5,000, I mean, sounds like a lot of money, but when you get into some of the things that have to be done, it goes very quickly.
I'd like to recommend we add a digit to that.
Do you have a preferred digit?
To make it simple, let's just add a 0.
Okay.
Make it 50,000.
Yeah.
Do we have any information on properties that we've had, regardless of whether it's cannabis or ag or anything, as far as on the cost to restore a property? In other words, I'm looking for something to base this on.
That's a great idea.
A digit.
Thank you.
I don't have that data offhand, but we'd be happy to add that, or should the commission want to add that to the recommendation, staff can compile that sort of information if we have it available.
Yeah, research what is a reasonable thing. I think $5,000, you know, you're hardly getting your foot in the door with. If anybody's ever done any sort of construction, you know that, you know, in a blink of an eye, that $5,000 is gone.
Thank you. Yes, I could agree to a digit with some background research so that it is based on something, rather than just a figure we toss out.
Shall I continue?
Yes, please.
That concludes the task force recommendations. The next section is staff recommendations that have not been considered by the task force or the board yet. Go ahead.
Before we move on, Chair, if I could ask a question, going back to, or staying with what the task force recommended since we received this map. If I can ask a question pertaining, or comment pertaining to that before we move on.
Yes, go ahead.
So in the map that we received, there are pink splotches. Again, this is kind of hard to read with my eyes. But are the pink areas, are those the areas that are designated?
Yes, those are the boundaries of the farmland protection zone.
Okay. So in my comment, basically, again, as we all know, the Cannabis Task Force, actually, I think the beginning here in the opening paragraph of this executive summary, it states that this update has been going on with the Cannabis Task Force for over 2 years, and actually, in reality, it's been almost 3 years, which is quite an amount of time since we've been in the effort of trying to update the ordinance, and that has seen many changes both in the industry and also with the Board of Supervisors and this board here. I would suggest, and I did listen to the Board of Supervisors meeting, I forget which date it was, where there was some, I believe it was just 2 supervisors that said they did not want to revisit the farm protection zones. I believe that was at the January meeting, where again, there are 2 new supervisors. I would, I guess, just, rather than shutting the door on that completely, I would like to see that opened up, because I see on the map there is no pink areas designated in the District 1 area. And not to say I don't have anything that I'm putting out there now that I think should be included, but I just think doors should not be closed on that discussion.
I'd like to second that.
Mm-hmm.
Thank you.
So do you have a proposal for when and who would have this conversation, or?
If I understand correctly, that would be a recommendation from the commission that the board revisit the boundaries of the farmland protection zone.
Exactly. Well put. Thank you.
Yeah, thank you.
Moving forward, remaining recommendations. The first bullet point, synchronize ownership description requirements with the state application. The Treasurer Tax Collector, Patrick Sullivan, did present to the board some challenges that his department was experiencing in trying to track down who exactly or which entity exactly was responsible for payment of taxes. He attributed this challenge because there is a lack of synchronicity regarding ownership declarations on the application versus what is required by the state, and proposed that if we were to synchronize our application requirements, that would actually help his department. And so the board, staff is bringing that recommendation to the board.
Thank you.
Not just for that one, we would also like to seek additional synchronization with state regulations to simplify where possible. This is actually just a regurgitation of previous board direction. But we would like to look throughout the entire application process to see where appropriate we could make recommendations to the board for synchronization for the purpose of streamlining our application process. Part of the board direction is not just to support our local permittees for legal cannabis activity, but also to have a zero tolerance for those who are not trying to operate within the regulations of the county and the state. And so one of the recommendations that we have brought, where we intend to bring to the board, is to allow for a reason of revocation recommendation to include unpermitted cannabis activity off-site by a permittee. Next one.
Really quickly on that one. So if an applicant has, they have an application or a use permit, and then they're doing something off the site, and then they would revoke their permit.
It could result in a recommendation of revocation of a use permit, or, thank you for saying it differently because that just got me thinking, additionally result in a denial, a departmental denial for an application.
Okay. Thank you.
We are also always looking for internal processes that we can streamline to simplify the application process. And additionally, in that same bullet point, though I don't know why I stuck them together, sorry, is resulting from the processing of hemp permits that we have been doing so far this season. We do not have a setback between the premises where the cannabis cultivation is taking place and where hemp cultivation can take place. We would like the board to consider establishing such a setback to aid our staff when they're in the field to be able to better differentiate what is the cannabis cultivation area and what is a hemp cultivation area.
Before you move on, can you describe perhaps a couple of those internal processes to improve the improvements for the streamlining?
I didn't have anything in particular in mind yet. Mary, do you know of any?
Not to put you on the spot, but.
With this implementation for internal processes to improve streamlining and simplifying, this would be specific from my perspective to amendments to use permit. These are use permits that are already approved projects. They have operated. However, over the course of time, the operators have determined their farm is missing an element, whether it be a processing facility or wanting a section for immature plant propagation, those types of things. So being able to streamline processing a project that has already been approved by utilizing some of those same studies originally and then updating any technical memorandums as required, if there's additional water use, things like that, would be extremely helpful for staff when we're going through this, because we are treating amendments to use permit as brand new use permits. So we are requiring all of the same requirements for these folks to go back through the process again after they've already done it and been in operations and determined where their farm is lacking this particular area.
Can I ask a question on the consider adding setbacks for commercial hemp and cannabis? What is the thought behind that?
Go ahead, tell them what you're seeing.
At this time, there is no official setback between hemp and cannabis. The hemp ordinance does state that they must be on a separate premise. So with that, the state of California has identified different swaths or patches of land, and it's only to be separated by signage where the hemp is located. We've had several discussions with the agricultural department staff on how we would address this and how we would move forward while we're issuing zoning permits for hemp, also working with the ag department, because hemp is a crop that's under their purview. We would just issue the land use entitlement and not oversee that crop the same way we do with cannabis. So we want to just tighten up those loose ends and make sure that we can identify in the field the separation of distances between the two crops, and make sure that there's no other underlying issues pertaining to those two crops being grown on the same parcel, separate premise.
Additionally, in a few of the visits that code enforcement has done out into the same area that Mr. Wilson was talking about earlier, we did find not only 3 illegal cannabis grows, but we also found one of our permittees that had just expanded their canopy to grow outdoors, which was not part of their permit. It would be very helpful in future ways for us to identify that kind of a situation if there's supposed to be a setback between the cannabis and the hemp as well. Right now, if that person has a hemp permit, they could just grow right up to the fence. And so it's to help us identify more clearly and differentiate what is permitted and what is not. Also, in the last part of that one bullet point is we would like the board to consider setbacks between commercial hemp and off-site residences. That does not exist yet. Again, that is also to mitigate odor impacts.
Okay. I just want to go back to, I'm sorry. I wanted to go back to the point before, the internal process improvements, and I don't need an answer to this right now, but I did want to just make a comment, and perhaps this is to be talked about at a later date, but in the short time that I've served as planning commissioner and different projects I've seen come through, is that I have seen that some people are in the queue, so to speak, for 4 years or so, before their project gets brought here before the planning commission. And so I'm just wondering, in all of this that we're discussing today, how can we streamline that process so that projects, whether it's cannabis or anything, is seen by the planning commissioner the Planning Commission in 2 years or less.
I appreciate that, actually.
And I'm
To
sure
the
that there
extent-
are, some learning steps along the way here, but.
Well, when we're looking for internal streamlining, I am actually limiting that to projects that are complete and remain stable as far as the project description goes. When you're seeing 4-year permits, not so much years ago when we had an overwhelming number of permits, but right now with our existing staff that is all pretty well experienced in processing these permits, the longer term delays could be for changes changes in the project description that then require us to analyze those for CEQA as well. And so that can result in those types of extensions. But also an internal policy that we would like to establish is similar to the state in addressing stagnant applications. Those that aren't moving, those that have been incomplete, can just automatically be denied by our department or withdrawn. And that is an internal streamlining that'll help with that also. Next. The code, the way it's currently codified, allows for recommendations of revocation to go either to the Planning Commission or to the Board of Supervisors. Because the application, or because these appeals typically have, actually all of them, have resulted in appeals to the Board of Supervisors, I would like to actually start taking these appeals directly to the Board of Supervisors. I wanted to run that by you before that recommendation goes before the board to see if the Planning Commission really still wants to be the first hearing body on those appeals. It will save significant staff time, that being my time, actually, since I do the appeals, to take it to the board, and then the appellant still has their due process rights that to appeal a board decision, but it would be to the Superior Court.
And then it would cost the applicant less also, because they don't have to go through the appeal process.
They'd save $1,000. I don't know what the fees are for court, though, because that would still...
Right.
I'm sorry, I thought they appealed to the Board of Supervisors.
Currently, I take recommendations of revocation to the Planning Commission, and then due process allows for an appeal of any Planning Commission to the Board of Supervisors.
So I would think that your question should be addressed to the Board of Supervisors, whether they want us to deal with it primarily or not.
Mm-hmm. I absolutely intend to take that to the board. As usual, they would want to know what the Planning Commission recommends as well.
I am fine with it moving forward to the Board of Supervisors. So unless, of course, they would prefer that it come to us first.
I'm all in favor of whatever thing is most efficient.
Yeah.
Thank you.
I kind of appreciate having or going through these projects that are denied, just because we get an idea of how we approve the projects that we're...
This would be limited to revocations.
Revocations, yeah.
Mm-hmm. Not denied projects.
Mm-hmm. Oh, yeah.
Right.
Oh, right.
So
Right.
any
You're talking-
projects that are for revocation, we do the hearing. And then you're saying that basically after they go and do an appeal right away. So I guess I was kind of just using that as using those revocation processes to see how the initial applications, how to deal with new projects that come before the commission for approval. So we're able to see, what kind of things to look for, and potentially like what kind of questions we should be asking the new projects that are being applied for. So I don't know. I do learn a lot from these revocation hearings, and just seeing what not to approve in the projects that are coming to the commission.
But if I can make a suggestion too, is that we can watch that either by attending the Board of Supervisors meeting and learning that way, or watching the video clip of the supervisor at your convenience.
That is true. Thank you.
And so along the line of saving staff time and time and money for the applicant as well, I'm all for it, the efficiency and just having it go directly to revocations, going directly to the Board of Supervisors.
Yeah, I agree with you. And I don't think we get that many. So
It's used as a last resort in our department. We really want to avoid them if we can. So I see 3. That counts as consensus unless there's any further. Okay. I'm writing that one down. And that concludes the staff-related recommendations. I am open to any further questions. Are there any topics that the commission sees as missing from this list that you want to make sure the board considers? We're open to your input, please. Thank you.
I just have a question on the second page of your memo. It says, as of the date of this memorandum, and it notes how many applications are in the queue, and those are being considered. So is there a map that we can find someplace that has where all these are through the county, so we get a sense of just a sense of the distribution or just where they are? It's hard when we get a recommendation or a request to approve an application and we only see the one application. We don't see it in the global sense of everything that's around. And so sometimes we're approving things sort of in a silo. We approve this one, then we may approve another and not see the entirety of the of what's going on there. So there may be a map.
A normal part of our presentation for each proposed use permit is to show permits both approved and pending within a 1 mile and 3 mile radius. We will continue to include that, but we would also be happy to show you a comprehensive map should the Planning Commission desire that as well, countywide.
Yeah, I mean, if there's one existing on the website, help me find it.
We don't have it on the website.
Okay. I would like to see it.
So would I.
perfect.
Do we have a
Oh, you had a question?
I'm trying to get the pages right, but in my notes from the reading, I have it on page 10. Prohibited activities, tree removal, section 27.3, reads, the removal of any commercial tree species as defined by the California Code of Regulations, section 895.1, commercial species for the Coast Forest District and Northern Forest District, and the removal of any true oak species or tan oak for the purpose of developing a cannabis cultivation site should be avoided and minimized. I'd like to see that changed to actually prohibited, not just avoided.
Miley, are you in your attachment 2 or 1 or something? And
I'm not sure which attachment it is, but it was the COTF recommendations that were provided to us last week.
okay.
It may help the commission to know that we do have a parallel process going on right now regarding development of an oak preservation policy, in which case, once that would be approved by the Board of Supervisors, it would apply to all discretionary use permits. So in other words, that may be coming back specifically for this commission to consider in the future.
Thank you.
All right. Any further questions from the commission?
I think we need to address water consumption in this, and maybe I'm not understanding the process, but we had a lot of input about water for today's discussion, not in this room, but in written form. And I'd like to hear what is being done to, I learned a lot today from the woman who spoke from the State Water Board, but is there anything we're doing to protect our water resources, are we requiring hydrology reports?
Yes, the zoning ordinance does allow for the department to require any report that they deem necessary for analysis of a project. And so we have, since the drought proclamation was rescinded, we have continued to require hydrology reports for any discretionary use permit that is proposing ground or surface water use. So not for those using municipal water, but any permit that proposes using ground from a well or surface water does require a hydrology report. We are also currently working internally to establish a criteria required for hydrology reports so that they will be more standardized and also be easier for both the public and the commission and staff to understand and apply in our staff reports and our evaluation.
I'm very glad to hear that. I'd also like to suggest and urge you to do it in-house, because I see these people hiring their own hydrologists, and I know that anytime you hire somebody, there's a sense of obligation to do what the person who's paying your fee wants. And I'd like to see it done more objectively. That's all. Thanks.
We have worked internally regarding past recommendations from or input from the Planning Commission to hire to contract with professionals for the cultural resources report, as well as possibly we have talked about the hydrology reports as well. We're encountering challenges, just so you know, because there aren't a lot of hydrogeologists to go around. So that's why we're focusing more on criteria that should be required in the report, so that we can all use them and won't just need, it's not like a secret language that has to go from one hydrogeologist to another. So we're trying to bring that more into a usable condition.
All right, so I'm going to open up public input. I would like each person that is going to come to speak to cite which specific bullet point that starts on where we left off, right after site reclamation bond. If you would like to comment on any of those bullet points, state which one, and then proceed with your comment.
Good morning, Chair Chavez, Commissioners. Actually, mine actually stood up to talk about the site reclamation bond, if it's okay. Just so you know, that raising it from $5,000 to $50,000, if in absence of anything else, is probably necessary. But I would like to point out that in the conversation March 18th in the Board of Supervisors, there's a lot of discussion about why cannabis has a reclamation bond. Do other industries have it? Things of that nature. And one of the things that came out of that is because the way the permit is set up, and perhaps Director Turner can explain it better than I can, the same difficulties Treasurer Sullivan's having collecting and code enforcement, things like that. It's difficult for that to be done in the cannabis industry. So there was an alternative discussion that if you can tie the landowner to the permit, then code enforcement could use their powers to do what a reclamation bond might entail. So I just wanted to point that out. The other thing is on the Oaks, couple things. One of the things we're noticing is that when applicants get their land, is they'll do things like grading for one pretext, or oak removal for another pretext, or well drilling for another pretext. Once that's done, then they open up the permit and they claim it as a pre-existing state. So there are things that you can do. I don't know if my mic's still on. There are things you can do in the ordinance structure so that that kind of game playing stops. You can say, if you're going to remove this for this type of purpose, you cannot apply for a permit for some other purpose for X amount of years. Otherwise, it becomes part of that. So if you're going to drill a well for domestic use, but your true intent is for cannabis, then you can't use that well for cannabis. You'll have to wait. That would provide some level of protection, and there's language that can be used in those other permitting processes to provide that protection. And then on the hydrologist idea, I think that's an excellent idea. The other issue we see is you hire the ologist, whether it's hydrologist, geologist, biologist, that gives you the answer you want to hear. And even if the county has its own, you can't see what they don't tell you. So one of the best practices is for the county to assign an independent hydrologist to do that inspection. And it would be just like you're basically inspecting the land to see if it's suitable. So it's like a home inspection. If I walked in and the planning department says, you don't need to inspect my home because my electrician said it was okay, it'd be on my property faster than you could say.
That is our 3-minute timer.
Yeah, thank you. But you get the idea. You can do it independently. Doesn't cost the county any more money. Doesn't cost the applicant any more money. But they're not tied to the applicant. Thank you.
Thank you. I'm going to take one of the hands in the Zoom room. Please be sure to state which topic on the staff memorandum you would like to comment on. And you will have 3 minutes. Please state your first and last name.
Hi, this is Maria Kahn. I wanted to commend the commissioners regarding upping the site reclamation bond. We know from past experience, and you probably are all sick and tired of me bringing up Sours, but I do speak with Jonathan Walters, who is a Sours guy, and they said that they initially put in $1 million to restore the land after Sours left, and they were expecting to put in another $1 million. So that was a very large project, but I think maybe the bonds could maybe have a couple different levels of bonds for the very small ones up to the very large ones. And 50,000, I don't think is unjust for any reclamation. That's a lot of money to have to restore land with various different departments that need to be involved to do that, like Fish and Game and all that. So I just want to say thank you to the commissioners that discussed that and bringing that the bond amount up. I think that's appropriate, and thank you very much for what you're doing here. Thank you.
Thank you for your comment. We had another hand in the Zoom room.
Yeah, it's a guest.
Guest, be sure to cite which topic in the staff memorandum you would like to comment on. State your first and last name, and you'll have 3 minutes.
Hi, Skylar Lewan, and I wanted to speak urgently and clearly about 3 recommendations from the supervisors and staff that raise legal and ethical red flags. The first recommended text, a warranty check for property owners and applicants conducted by the Lake County Sheriff's Office for criminal activity warrants resulting in the possible suspension of an application. This is legally problematic because it creates risk violating due process. A warrant is not a conviction. It is an allegation, a procedural step. Automatically suspending someone's application based on a warrant turns suspicion into punishment without a hearing or a fair process. This is also in direct conflict with how the Department of Cannabis Control handles licensing. The DCC does not mandate denial or suspension based on a warrant alone. Applicants must be given a chance to respond and resolve their matters legally. Here's where the California Racial Justice Act comes in. This kind of a policy applied without safeguards opens the doors to racially biased outcomes. Black, brown, and indigenous communities have long been over-policed and therefore are more likely to have warrants or be under scrutiny. Using warrants to deny access to an opportunity is a form of systemic discrimination. And under AB 2542, that matters legally. The second recommended by staff, add suspension of the cultivation applications if the background check reveals an active warrant. We are looking at a presumption of guilt. This treats a pending warrant as if somebody has already been convicted, and that is not justice, that is profiling. It turns a procedural flag into a weapon for discrimination. and it conflicts directly with the California rehabilitation policies like Penal Code 4852, which promotes reentry, expungement, and integration, not permanent exclusion. The third recommended rule, allow for revocation recommendation of a use permit for the case of off-site unpermitted cannabis activities conducted by the permittee or the property owner. This is an extreme overreach. Revoking a land use permit for something that didn't even happen on the property or may not even be a part of the licensed business is an abuse of permitting power. This opens the door to constant surveillance and punishment based on somebody's private conduct or associations. That is not legal land use policy, it is harassment. And under the unconstitutional conditions doctrine, the government cannot place excessive, irrelevant conditions on your permit. What does California law say? SB 1294 promotes equity, second chances, and exclusion. The Department of Cannabis Control regulates, requires due process. Warrants are not an automatic disqualifier. Ban the Box and the Fair Chance Act protect against blanket disqualification based on criminal records. Penal Code 17B protects the pathways to rehabilitation. Is County of Lake exploiting a gray area? Yes. Is County of Lake using zoning law to enforce criminal consequences without a trial? It looks that way, and it's legal. County of Lake is using the land use and zoning as a backdoor disciplinary tool to legally criminalize cannabis farmers even further, particularly those who are trying to rehabilitate and operating legally. This is setting a dangerous precedent. I call on the board to pause the implementation and request a formal legal review of these proposed recommendations by staff and the Board of Supervisors. We owe it to our residents and especially those rebuilding our lives to ensure that we are not violating the spirit or the letter of the law. Moleham.
Thank you for your comment. All right, I'll take the hand in the chambers before I take another hand on Zoom. So if you would like to speak, state your first and last name for the record, and you'll have 3 minutes.
Hello, Autumn Carsey, Artemis Kopak. With all due respect, I would like to formally request the recusal of Commissioner Monica Rosenthal from providing input on the cannabis ordinance, that her comments be stricken from the record. Commissioner Rosenthal is a known member of the Community Action Plan, also known as CAP, an organization that has consistently opposed cannabis project and actively lobbied for more restrictive regulations. Commissioner Rosenthal has also independently opposed projects publicly. These efforts have resulted in increased staff burden, delays, and additional resource allocation by the county and the cost of county valuable tax revenue. Throughout the Cannabis Task Force process, Commissioner Rosenthal has demonstrated consistent bias, including signing into a CAP-sponsored letter calling for the expansion of the farmland production zone, a proposal that was already rejected by the Board of Supervisors, which was also mentioned here today. According to a geographic overlay analysis of this proposal, it would impact 59 out of 162 farms licensed today. That's 36.4% of all farms licensed in Lake County if this protection zone were to expand. Currently licensed farms, these businesses have invested millions in infrastructure, land improvements, and workforce development that would potentially be barred from license renewal if these recommendations were adopted. Also important to note that cannabis cultivation in Lake County is already subject to stringent regulations, including a 20-to-1 acreage requirement, which is 5% of total lot coverage. Given this context, the presence of a voting member of CAP, an advocacy organization with a clear and well-documented opposition to the cannabis industry, raises concerns about the objectivity of this process. If a CAP member is allowed to vote, then the fairness dictates that a voting seat should also be granted to the representative from the Lake County Cannabis Alliance, or LCCA, to ensure balanced representation. Commissioner Rosenthal's continued participation poses a conflict of interest and undermines the credibility of this process. Her vote is prejudicial to the legal cannabis industry in Lake County and respectfully should not be allowed to stand. Thank you.
Thank you for your comment. I did have one hand in the Zoom room.
No, we're good. There's no hands.
No hands in the Zoom room. Bringing it back to chambers, if there's any other hands in the Zoom room that would like to speak on the staff memorandum.
Chair Chavez, could we please have a 5-minute break? I think we may be experiencing technical difficulties on Zoom.
Okay.
Thank you.
We will take a 5-minute break. It is 11:22. We'll come back at 11:27. Thank you. Check, check. Hello. Welcome back. It is 10:28. We are experiencing some technical difficulties on Granicus. The Zoom link is working, and you guys can find that if you would like to continue watching. It is on the agenda for today. There's a link, and it tells you the passcode. So you guys can join us on there. So we will continue our meeting where we left off. So. And where were we? Yeah, I think we were still public input is still open. If anybody wishes to speak on anything in today's agenda, specifically on the memorandum, and any topic from where we left off under site reclamation bond.
Okay, my name is Danielle Fontenot. I have a question about the prohibited activities in the electrical generators. It was on the agenda, but we haven't touched on it yet. I just wanted to make sure that we talked about it, I guess.
Yeah, I don't think that was part of the changes, was it? Or I think we did speak about it at the beginning.
It wasn't part of the most recent updates, but it's available should the commission, I did include it as the attachments from previous updates, should the commission want to go back and revisit items.
Yes, Commissioner, Chair, I would like to be able to go through both attachment 1 and 2 to discuss some of the, not to get too anal or too detailed, but I would like to, after public comment is done, to be able to kind of go through this and then, and there may be additional public comment, I'm not sure, but
Okay, yeah, that sounds good.
beyond just what we have gone through with the staff report.
Yeah, so we'll continue with your comment. So if you, again, please state your first and last name, and we'll give you 3 minutes.
Danielle Fontenot. I just wanted to say that prohibiting the use of generators for cultivation, for outdoor cultivation, specifically when we're pushed out so far away and many of us are not on the grid and we don't have access to power or anything like that, have to use generators. So it would put a lot of us out of business, very likely, if you guys did that. And that's all I have to say.
Thank you for your comment. Are there any further?
Michael Green again. On the surety bonds, again, where we can align with the state and streamline this process, let's do that. State licensing process requires only a surety bond of $5,000. It says at least, so I guess people conceivably could, but if you download the form you need for a state license, it's right there. $5,000 surety bond, you're off and running at the state level. I'm just informed, talking with the industry person, you may not be able to get surety bonds for an excess of that amount. So if we're going to be throwing digits at the end of surety bonds, let's make sure there's a nexus there for the need of remediation, and let's understand why the local process would require a greater surety bond than the state requires. On the hydrology reports, I object to the characterization that a hydrogeologist who prepares a report for a paying client is inherently biased. These are state licensed professionals. I'm aware of another project that came before this body that was denied in part because of concerns over the hydrogeology report. And the question from that professional after the fact was, did they read it? Did it hit all the points that the ordinance required? And if they objected to it, on what basis? What substantial evidence do they have that they're experts, that they can reject or call opinionated or biased a report from a state licensed professional? Now, he wasn't a hydrogeologist, he was a civil engineer, but nonetheless, he submitted a report that hit all the bullet points in the ordinance, satisfied all the requirements, and this body decided to go in a different direction based on what we don't know. So bias can come from any number of sources. So the automatic standing accusation that a project supplied hydrology report is insufficient or biased should be rejected. And if you do continue to go down that path and insist that CDD find some hired gun to do it, guess what? CDD has been accused of bias before too, not fairly, but it does happen. And if they can't find a house geologist, hydrogeologist to do it, you know, we can talk about streamlining all you want, but it ain't going to happen. Thank you.
Thank you for your comment.
Can I just add that I think that Director Turner had said that there's going to be evaluation or look at the hydrology reports. Was I understanding that correctly?
Yes.
As that goes through the process, will that then come to us for review and conversation? Because I know that is a conversation and a concern globally. So one of my wonderments is that there's a standardization of nomenclature and numbers to help us. I'll just say me, to make sure that I understand everything that's being said when they're, you know, they talk about, you know, acre feet, then gallons, and I mean, I can do the math, but, you know, to make it as clear and as easy for everybody to understand, because it is complicated. And so I think that your evaluation will be helpful, but to help us so that we can do a better job to understand all those parts and pieces. So if we could have that incorporated into our process of learning as well.
Certainly.
Thank you.
All right. First and last name for the record, and you'll have 3 minutes.
Thank you, Chair. Margot Kambara. I would like to comment on water issues, hydrology, that was being covered right now during the agenda. And I would like to mention that Commissioner Field brings up good points when we say we should take a closer look at water data, water availability, hydrology reports. And I'm heartened to hear that there is a concern and effort will go behind standardizing the hydrology reports. In terms of best practices, I think it would behoove the county to eliminate even the appearance of conflict of interest. And so it would be best to hire an independent contractor or in-house hydrologist to conduct the required analysis for water availability, the suitability of the site to sustain that operation as planned. Right now, that is not happening. The county does not have the resources as the structure is currently exists. A solution exists, though, so we can have independence, and that is the fees for the cannabis project permit can go towards an independent hydrologist to look into the suitability of that site. Right now, the applicant pays for the hydrologist. And I appreciate the earlier public commenter saying that, well, you should not assume that the hired gun for the applicant is not going to tell the truth. Granted, but let's employ best practices. Let's get an independent professional to evaluate the site. I also bring to your commission's attention a written comment submitted on this agenda item by, rats, I can't find her name. Hang on. Environmental professional Peggy Lee. She raises important points about water consumption and the cannabis and projects being considered. Specifically, the cannabis program's impact to the Sustainable Groundwater Management Act, and in general, we need more vigor and consistency in the project hydrology reports and the tests of water availability. The county does not use safe yield as a criterion for judging water availability. That should be included. Thank you.
Thank you for your comment. We'll take another comment here in the chambers before we check Zoom. Say your first and last name.
Bill Wilson. First off, I'd like to I thought the regulations ordinance in the county said that hemp was not allowed to be grown outside of a greenhouse if there's any pollination, any pollinators, if there were, that had to be pulled out. So hemp is required to be grown in a greenhouse. Cannabis isn't. But the second thing is, before the first break, and we were still on odor, I have problems with using the mitigated negative declarations because according to it says that if there's any determination whether the project has any significant adverse effects on the environment, you have to have an EIR. And I think things like odor, Lake County Air Quality District, Chapter 1, General Provisions says, any discharge, release, or propagation of into the atmosphere, which includes, but not limited to, smoke, dust, soot, fumes, odors, or any other combination thereof, is not allowed. That's the air quality. As far as water, I don't know if the county is monitoring it, but I have pictures of the meter that they're supposed to have, the water meter. In 1 year, they used 714,000 gallons of water, and their report to the county says they used 106,000 gallons of water. So is anybody monitoring that? Thank you.
Thank you for your comment. I'm going to take one hand in the Zoom room. Do we have any hands in the Zoom?
Yeah, we have 3 hands.
All right, let's do one hand in the Zoom room.
Okay, first one is a guest.
Hello, guest. State your first and last name. And
Thank you, Commissioner Chavez. My name is Angela Amaral. A few things. Going to the surety, the reclamation bond, surety bond. Just so you guys know, there is a surety bond for hemp that has levels for minimum requirements based on project size. Also, to the hemp point, I think the Board of Supervisors has the understanding that the hemp ordinance, or it was their intention, the hemp ordinance does not allow for cultivation of cannabis and hemp on the same parcel. This was discussed during a cannabis appeal at the Board of Supervisors earlier this year for a project in Kelseyville. So I'm not sure if there's a confusion of whether hemp and cannabis can be cultivated on the same parcel. As staff has stated here, it's difficult to differentiate by site only. A couple other things concerns that weren't discussed here. I would like to see it adding a request to have the permit application require properties located in an HOA or POA to supply a letter of approval. It's one of the issues that we've had to deal with out here. And then also a requirement for property taxes to be current alongside with cultivation taxes. Right now, the ordinance only requires that cultivation taxes be current, not property taxes. And I think that's another big issue that we need to address. I'd also like to state that I agree with Commissioner Fields that the oak tree removal should be prohibited to the greatest extent that it can be. Thank you.
Thank you for your comment. We'll take the hand in the chambers.
Good morning, Chair Chavez and Commissioners. Through the chair, I have a question.
First and last name for the...
Excuse me, Andrew Dobbs Kramer. Thank you. Through the chair, I have actually a question for County Council. I believe a conflict of interest has been identified here today, and I believe government code requires that be responded to and addressed before we proceed with the meeting. I don't believe we can simply just move past that. So I'm curious if County Council has any thoughts on that. Thank you.
I've already advised the individual who has a perceived conflict.
Okay, so...
Chair, would you like me to respond?
If you would like to respond, yes.
So first off, thank you very much, Adam Corsi, for giving some recognition to the Community Action Group. That group is doing some good work here in Lake County and has some good participants involved in it, looking at a variety of different projects throughout Lake County, including the Lake Pillsbury project. I was a founding member of CAP, and upon taking the Planning Commission position, I did remove myself from CAP. I no longer participate in decisions or letters or positions with the organization. However, I am familiar with their work, the same way I am familiar with the Lake County Cannabis Alliance work, of which there is one member that served on the Cannabis Committee, the task force committee, along with another member who both had individual personal financial interest, but yet served on the cannabis task force. Regardless, I respect their opinions. In fact, one spoke earlier today talking about lowering legal barriers. Having been a farmer since the mid-'80s here in Lake County, I can totally agree with that. And I welcome all of the cannabis industry to farming, which it has been overburdened by regulations for years upon years. So that we are in full agreement with in lessening. With those comments, I would like to say that I feel I can serve, and I have taken this position to serve, and I can serve in an unbiased manner to make the best decisions for the County of Lake. Thank you.
All right, so we will continue with the hand in the room, in the Zoom room.
Yeah. Betsy Kahn.
Please state your first and last name for the record, and
Thank you.
you'll have 3 minutes.
Central Public Information Center. I want to comment on the question about the evaluation of available water and the use of the explanation that every permit considers the cumulative impacts within 1 mile and 3 miles of the existing permit application. I've watched these hearings and observed that even though the planner presents a slide that says there are X number of projects within 1 mile and X number within 3 miles, no analysis is done of the cumulative impact of all of those extractions that have been authorized and the current application. This is a subject that I've written to the grand jury about. I believe that the Planning Commission a couple of 3 years ago heard a presentation about the necessity to establish thresholds for evaluations of this critical component of our environment. It still does not exist, and I think it's very important that you keep in mind that every time you issue a new permit, you say, well, we don't know what the cumulative impact is because we don't have a tool to do that. I think you need to develop that tool and consider those cumulative impacts. We also have a state requirement for drought management planning, and currently the Community Development Department is responsible for the development and implementation of a plan that addresses small water systems, 15 units or less, and domestic wells, but there is no agency or organization that is at this time assigned to address the future drought planning for all of those groundwater basins that you are permitting to be used for cannabis operations. Thank you.
Thank you for your comment. Another hand in the Zoom room.
Yeah, Richard Durham.
Richard Durham. Please say your first and last name for the record, and you'll have 3 minutes.
Yes, my name is Richard Durham. Thank you. Let me know if I'm speaking out of turn here. It's about an item on attachment number 1. Can I speak to that?
Is it activities zoning permits attachment?
No, it's the type 9 retail delivery only.
Yeah, if you're on attachment 1, it's the summary of COTF and Board of Supervisors recommendations on cannabis types.
So in there it says allowing this type of business to be available, permitted cultivators. The business model discussed included tourists visiting cultivation site with the ability to purchase local products to be delivered where they are staying. I'm wondering, why can't the person who purchased the local product just take it with them? Why are you making the cultivator run around town trying to find where these people are staying? And what if he has multiple sales? Let's say 5 people bought 1 ounce from him. Once he puts those 5 ounces in his car, now he's breaking the law when he's out on the road. So I'm wondering, why was that put in? And if so, could it be removed? Thank you.
Thank you for your comment.
I had a difficult time understanding that.
I think I understood it. The speaker is questioning at the bottom of page 1 on attachment 1, the summary of COT, FPC, and BOS recommendations on cannabis permit types. Type 9 retail delivery only. He's questioning why it would need to be delivered and why couldn't somebody just pick it up on location.
The note says to alleviate the pressure of the C2 zoning district where community main streets are located. Well, that's the reason for the
I'd be happy
for
to
allowing
address
that.
this if the chair would like me to. These are different license types that are available at the state. Type 9 is retail, which is delivery only, which does not include a storefront, whereas the line below it is type 10, which is retail storefront. So the task force and the board wanted to allow different options for cultivators, one of which being either you just deliver it to them or you apply for a type 10, which is a storefront, in which case you're encountering this level of permitting for that to be allowed as well. So to remove it would actually remove an option available for our current permittees, and the board was interested in increasing the amount of options for current permittees.
Thank you. I learned something, and I compare it to my own farming operation. I grow pears, but I do not sell them retail. I don't have a retail location. But if someone comes to town and wants to buy some pears, I'd like to be able to deliver them to their hotel.
The discussion at the task force centered around mirroring kind of the winery industry as sort of an agritourism option for cannabis in the future.
And we'll take the next comment.
Nara Dahlbacher?
All right, Nora, state your first and
Hi.
last name, and you have
Yes.
3 minutes.
Great. Hi, Nara Dahlbacher again. Again with LCCA and also served on the task force. I do want to just comment on the request for recusal and some of the things that were stated on the task force. The folks that were appointed who work with the cannabis industry, myself and Jennifer Smith, were seated in cannabis-specific seats on that task force, one for the LCCA and one for the cannabis industry, both of whom are stakeholders, and we represented those interests with transparency. And I think that what we should look at is potentially the letters that Commissioner Rosenthal signed her name to and the policies that are listed within those, and see whether things that fall under a period of time when she was signing the letters are policies that perhaps should be recused, or at least get some kind of a written response from the county about this. There are votes coming up in the future, and this is the District 1 representation. District 1 has a lot of cannabis businesses and a number that would be incredibly negatively impacted by the suggestions in the cap letter. And we need to know that our representative, I live in District 1, our representative in District 1 is representing the entirety of the community, including the cannabis businesses that are in District 1. And I actually I did not have any financial interest in any cannabis in Lake County. I'm not a cannabis business owner. I'm a licensing and government relations expert, and I chose not to take a single client in Lake County because I didn't want to have a conflict of interest while I served on the task force, and I served for 2 years longer than I thought I was going to, so it wound up being a bit of a financial hardship for me. So I really take issue with any accusation that I was financially benefiting in any way from my service on the task force. Thank you.
All right, thank you for your comment. And just a note to keep all comments relating to what we're discussing today, which are the recommendations on the cannabis permit types and the staff memorandum. Thank you. Can I get the next speaker?
Yeah, Jordan Poole.
All right, Jordan, we're going to state your first and last name for the record, and you'll have 3 minutes.
Yeah, Jordan Poole. I just wanted to comment on the water concerns that I've been hearing a lot about. There's 11,000 acres of grapes planted in Lake County using over 2.5 billion gallons of water a year. I think just, expanding stricter regulations on cannabis when I think there's, correct me if I'm wrong, under 200 acres planted. I think that's just kind of overreaching, especially compared to the sheer volume of water used, 200,000 gallons an acre about on grapes. It just seems just like a overreach. Thank you.
Thank you for your comment. Another hand in the Zoom room.
No, we're good.
I believe that's all the hands in the Zoom room. Bring it back to the chambers for any further comments. All right, I see one. First and last name.
Mr. Chair, I have a question about following the agenda. At some point, will there be an opportunity for public comment on this agenda topic in general, like an overall comment about the staff report or staff recommendations?
You can do your comment now if you would like.
Well, thank you. I appreciate that.
3 minutes.
Certainly. Commissioners, thank you for this opportunity. Margot Kambara. Revising the ordinance alone will not eliminate major cannabis issues in our county. There are cannabis problems in the county that won't be fixed just by revising the ordinance. We've heard of it just today. We heard citizens bring up the question, is staffing level adequate? It's written in the ordinance that we're going to change setbacks maybe, especially for odor. Will that fix it? Well, if there's a complaint, just call code enforcement. Code enforcement will take care of it. We found it's been years since complaints have been made at the same site about odor complaints. It hasn't been resolved. So that's what I mean by just revising the ordinance alone won't fix the problems. There are problems with the mechanics of the cannabis program. Not enough staffing, not enough staff to do what is in the ordinance to make sure that everything works properly. The annual reports are required now. Among the points on the annual report, look at water usage. We know that there are growers who are exceeding their water usage, but there are no consequences. And then we have professionals in the environmental field who are cautioning us, we are in a drought as a state. We should be careful about our use of groundwater. We have a basin that is under state observation. We need to be very mindful of our water usage. So that is just an example of how it's short-sighted now to think that just revising these ordinances will fix our problems. Not only that, there are major issues that were raised by the public that have not been addressed. They are not addressed in the pages and pages of recommendations that staff and the task force have brought to you. They're not even addressed. They were of the dozens of issues. CDD and COTF agreed to address maybe 2 or 3 of them, but the task force was disbanded before that was even considered. So what you are looking at is an incomplete pie, a half-baked cake. And really to do justice to the county, for this to be a win-win for everybody, for the industry, for citizens, for the county, we need to include and address public concerns. Thank you.
Thank you for your comment. First and last name?
Tom Lasik again. Good afternoon. I'm not sure what the process is here, but as I mentioned at the very beginning, there were a set of comments that the community put forth that were supposed to have been included in the ordinance revisions, and it didn't make it in there. And I think that's in the public comment section. Before I go on, if it's going to be discussed, I can wait, but if it's not, I can continue. So, because there's a couple things there I did want to discuss while I had the chance.
Well, you can discuss them now. We'll still have to bring it back to the board.
Okay, so in the recommendations from the community, there was a discussion about homeschools. I know this came up in front of the Planning Commission a month or two ago. And you were told that you don't have the authority to make that decision. But you now have the authority to make that recommendation that homeschools be included as one of the types of schools that are offered the same protections as other public and private schools. Since COVID, we've had a lot more homeschooling occur. As you know, in that hearing, it came up, and and Mr. Green here, I don't know yeah, he's still here. Hi. He mentioned that when they were building the ordinance, they considered homeschools, but they couldn't find a way to get it in there without the applicant self-declaring. So apparently at one time there was a desire to not exclude homeschools. So I encourage the commission to ask for that if that's something that you feel you want, because it was clear a month or so ago that was something. The other thing related to schools is that the setback in the schools in the ordinance is not the same as what it is in the state. The state language is 600 feet from parcel boundary to parcel boundary. And here in the county, it's 1,000 foot from the cultivation site to the school parcel boundary. You would think that would be more protective, but in the research I've done, it's not necessarily so. So I've looked at the Cobb School, I've looked at the Middletown campus, the Lower Lake campus, Lucerne, Upper Lake. I have not yet looked at Kelseyville, which is an unincorporated area, and I haven't looked at the private schools. But for the most part, the way the language in the state actually provides more protection. So what I would encourage is to maybe take a look at that language and say 600 feet from parcel boundary to parcel boundary, or 1,000 feet, whichever provides the most protection. Because the way it's set up, it's goofy, and I can provide. I'll close it real quick. I can provide in a later comment the maps that show what I've been able to find. Thank you.
Thank you for your comment. Are there any more comments in chambers?
Hi, Michael Green. Just for the record, no drought right now. I know this because I spent 3 long meetings trying to undo a couple of drought proclamations and a couple of drought-related ordinances. There is a requirement under state law, and this county has been very proactive in crafting required drought management plans. And in our cannabis permitting process, there's already a requirement also to come up with a drought management plan. And when the drought happens, and it will again for sure, we're going to apply those plans both locally, site-specific to the cannabis projects, and then the county as a whole will take certain actions under its drought management plan. But to the broader issue of, there's a drought, a never-ending drought, number one, not true. To the broader issue of water management, cumulative impacts. I have great respect for Betsy Kahn and EPIC and all that, and I understand even our ordinance calls for examination of cumulative impacts. But like the phone speaker also said, there's a whole lot of agriculture in this county that is not subjected to that same level of review. So as a practical matter, it's going to be really hard to do that cumulative analysis where you only cherry pick the cannabis farms within a given area or zip code and kind of ignore all the traditional agriculture that may be in the same basin. So I want to thank the commission finally. It's been a long morning, and I know you have a lot on your plate, and I know your recommendations will be considered duly by the Board of Supervisors when it comes. But it's been a long haul, and I'm glad to see even a little inching toward the finish line on this ordinance. And I do think the overall goals of streamlining, creating new license types, providing clarifications that are needed when they are needed to protect public health and safety. This is not our first rodeo, and you should have seen us in 2016 and 2017 as we were doing the first drafts of this ordinance. And I was a little lowly grower's advocate at that time, also not making a dime from it. So thank you for your time.
Thank you for your comment. We're still in public comment, so if you'd like to speak, state your first and last name for the record, and have 3 minutes.
Autumn Carsey, Artemis Copac. As somebody that has homeschooled their child in the past, it is very easy to get a homeschool certification. So that would mean that anyone that opposes a cannabis application can just register as a homeschool and knock that application out of the process. I think that's extremely prejudicial to this process and to cannabis operators. Thank you.
Thank you for your comment. Do we have any hands in the Zoom room?
No, Mr. Chair.
All right, no hands in the Zoom room. Last look in the chambers. We'll take one more in the chambers. Your first and last name.
Thank you, Chair. Margot Kambara. This will be brief. For your edification, commissioners, I draw your attention to the California Water Commission's white paper released January 2024. Title is Potential State Strategies for Protecting Communities and Fish and Wildlife in the Event of Drought. In this white paper, the authors inform communities such as ours that we are in a state of persistent drought. And for our own benefit and well-being, we should prepare. Thank you.
Thank you for your comment. Are there any any last hands in the Zoom room before we close public input? I'm seeing none. Last look in the Zoom room, and there's no more. So we'll be closing public input and bringing it back to the commission for further discussion. I guess I'd like to just if there was any things that you guys picked up from the comments that we received that you guys would like to explore further or make any recommendations or changes, right now would be the time to do so.
Well, again, if, again, this is up to to the chair and to my fellow commissioners, but I would like to go through attachment 1 and 2, in sequence page by page and see if any of us have comments on the items there, which some of those items include what the community here has brought before us.
Okay.
I guess my comment is that I did that last night, and I noted the things that were of issue to me, so I've already made comments on everything that I felt strongly about.
Is there a specific item that you would like to review?
Well, I did have one question, and this may be for staff. I have several questions, but to begin with, yes, I had a question which was brought up from a public comment from a green sheet we received as well. Anyway, but I don't really understand, or I wanted to find out what staff's comment may be on the SR and RR zones. So there was a comment that was made that was mentioned during the Board of Supervisors meeting, something about.
If you're referring to the green sheet that we had recommending cannabis permits be removed from suburban reserve and rural reserve, staff has no comment on that, actually, but that has already been a determination by the board. And so we do intend to take this public input as an attachment to the staff report going before the board so that they can address it at that time.
Thank you.
So,
and then the other, did you have a comment about that? The other comment that I had in regard to, and I'm on page 3 of attachment 1, in talking about cannabis special events. And I guess really my only comment about that is I would just like to make sure that we are consistent with regulations countywide for other activities, for both wine, for beer, for any special event. Which, again, I think that we brought that up before, consistency both within the county and also with state regulations, especially when it comes to cannabis.
We currently have a zoning permit process for a certain number of special events, but as exists in a number of our wineries or other venues, should it be used as a special event center or location for ongoing special events, that does require discretionary use permits. So the recommendation as it stands now, since a cannabis special event is not creating a special event center, but it's rather it's like a one-off, having a certain special event at a location at a certain date. The recommendation is to fold that one into our existing zoning permit for special events.
Okay, thank you. Any comments from my fellow commissioners on events?
No.
Can you just, when it says by state law, cannabis event requires a licensed event coordinator. I know what those words mean, but what does that mean practically?
So if you want to be a special event coordinator specific to cannabis, it requires its own license at the state level. You can't just be like, hey, let's wake up and have a special event for cannabis today. There's a lot more rules and regulation and sort of preparation at the state level as well as the local level in order to do that. One of which is actually getting a license to be a cannabis special event coordinator.
I think it'd be similar to having being like a third party bartender, or like when you would hire somebody that's licensed in bartending and they could bring their event to you or vice versa.
Kind of, yeah. It is a recognition of the guidelines that are required at the state level, and it is something that we would put in as a requirement for an application for a cannabis special event as well, to make sure that we're compliant with state law.
Thank you.
I have a procedural question. We've made a lot of comments today, but we haven't made any motions. And I'm wondering, how will our discussion be presented to the Board of Supervisors? And do we need to write something up or direct staff to write something up? Or
I appreciate that. I have been taking notes and was going to recap where consensus was established so that the commission can consider either taking action to that or to modify it if I got it wrong. So. And I'm happy to do that whenever the chair says it's time.
I'm satisfied with your taking notes and presenting them.
I've been typing furiously. I don't want to miss anything.
So if there's no further...
I have more comments.
Okay, continue.
So on page, I think it's page 7, I don't know, my pages here are not numbered in attachment 2. I think it's about page 7. Just talking about, it's a section talking about compliance monitoring, section 27.13, says page 27 through 155. In the COTF comments, it seems like that first paragraph in the box should be removed that states to reduce annual inspections to every other year unless there's a transfer of ownership. So, and I state that because, well, and then next it goes to compliance monitoring, which is inconsistent. Then it says that the cultivation site shall be conducted annually during the growing season.
The action or recommendation from the task force is to allow it to go to every other year after 5 years of inspections in good standing. We can work on clarifying that wording so it won't be confusing going forward.
Okay, thank you. Oh. And then a question for staff about the performance review process. So, and this is what I was referring to earlier on, I think, almost the very start of this meeting that I figured we would get to at some point. But how does that work where it states in the middle here, again, this is on the next page following the last comment that I had there, where it says the Planning Commission may delegate review of the annual performance review report to the director. So, but I just kind of wanted to get a feel of what all that is.
The way we're thinking that that's going to work is instead of giving you 120 and an ever increasing number of annual reports for you to review in open session, we would conduct our internal review and then bring you sort of like batch reports of these are all consistent with their project descriptions. These are where we've encountered some issues for further discussion. So it would be an easier way for the Planning Commission to consume that data in your meetings and not have, we'd not have to have meetings that are long enough for you to fully discuss and consider individually over 120 cannabis annual reports, but still make sure that that review is taking place.
Thank you. On the next page. On the next page, at the bottom, in regard to complaint records, and this is something that was brought up also during this meeting today, but I don't really understand exactly the entire complaint process and how it's handled, where it says the permittee shall maintain a record of all complaints and resolution of complaints and provide a tally and summary of issues.
This is currently required by the permittee. The task force does not want to make any changes to that requirement. They still want the permittee to be responsible for maintaining a collection of those complaints. This is actually a formatting change. So just changing the location of the where it would be in the code.
Okay. Great. And then in the next section, the identification of emergency contacts. In the COTF comment section there, it says that the applicant shall make every good faith effort to encourage neighborhood residents to call to this designated person to resolve operating problems, if any, before any calls or complaints are made to the county.
This is encouraging our permittees to be good neighbors, not scary people, and to do outreach to the community in a positive manner that would establish relationships so that neighbors, should they encounter a conflict or have a complaint, would feel comfortable reaching out to that permittee. It does not require or limit the public's ability to lodge a complaint with the Community Development Department.
Okay, thank you. Now, I know, again, around cannabis and stuff with all the security measures and stuff, there are issues associated there, but I know, with other businesses, such as for vineyards, the vineyard management company, if the property is being managed by a vineyard management company, then there has to be a sign on the vineyard indicating, who the management, in case somebody does have an issue, they can call that management company. And of course, we have with other businesses, we have a business directory, we have our Chamber of Commerce listings, and I'm just wondering, and I'm going to throw this out there to LCCA also, is how can you help, as far as in order for us all to be good neighbors and be able to connect with people rather than LLCs. So, moving on to the next comment that I had.
Did you want to answer?
Oh, no, I was just making a comment. But if you want to answer.
No. Your question is a good one. I just didn't know if you had a recommendation.
On the next page, I appreciate the change the title change from water use to diversion of water in that section. And let's see if I had more projects. Oh, and then the other question that I had is, again, I have no idea what page I'm on, but at the bottom of this page, it talks about prohibited activities, electric generators, et cetera. And I know we had one speaker today speak about generators. And I guess I just would like to put a plug into, I'm a little bit confused about exactly what the expectation is for the use of generators in regard to cannabis operations, especially in remote locations. And also, as one of the previous hearings that we had with the use of, I believe in one of the past applications, there was where the applicant was talking about using solar, and then with the generator backup. And that just seems to be kind of going into a different avenue also, and saying they're not using PG&E at all, they're relying on solar, and how does that impact the use of generators? So I would hope, and I would hope that my commissioners agree, that there needs to be a little bit more clarity around the use of generators for any agricultural industry.
Currently, our existing code does not address generator use for cultivation. It addresses, or outdoor cultivation. It does address it for other types, and we considered this an inadvertent omission in the code. That we took it to the task force, and they agreed and said that generator regulations should apply to all types of cannabis-related activities, including outdoor cultivation. Additionally, all generators should comply with the California Fire Code requirements to ensure that they're not going to be setting wildfires.
Just a comment. We had some public comments today about generators, and it occurred to me that we do have the technology now to have photovoltaics that can provide adequate power with batteries so that it's day in, day out, whether it's cloudy or not. Mm-hmm. I don't know legally whether we can require that in lieu of generators, but it's my understanding that generators that are run on fossil fuels are more likely to cause a fire than photovoltaics, but I'm no expert on this. So.
Additionally, there are requirements for safe storage of hazardous materials that are already in place and enforced by environmental health. Also, one moment. It has been conveyed to the board the extended time it takes either to get hooked up to PG&E or to build your solar system as well. So the board is aware of that also. But in general, generators are recommended for use only in unforeseen emergencies.
There are certain circumstances under the current code section for cannabis that allow generators only for emergencies, and there are criteria under which that occurs. And sort of generally speaking, an emergency is not the individual cultivator's emergency. It's an emergency that the cultivator had no control over. So earthquakes, fires, power outages, things like that. If there is not an outright prohibition or restriction already in the ordinance, that does not mean that a person has free reign to do as they please. They're still required to follow state law, local ordinances, fire code, all of the building codes, safety regulations, anything that would otherwise apply to the machinery that they are implementing or proposing to implement, and any kinds of fuels and ancillary chemicals that go along with that machinery. This includes a CEQA analysis, all of the generators that may be used with the project, any project, not just cannabis, but any growing project or a proposed project, must be identified up front. They must be analyzed as part of the CEQA analysis, and their impact must be mitigated. So if there is a proposal, for example, for cannabis grow in which generators are proposed to be used as an integral part of that business, those generators must be identified, and they must be analyzed, and all appropriate permitting associated with them, and all appropriate all of the permitting must be gained and maintained, and then all of the safety regulations that apply would also have to be followed, whether or not the ordinance, the county ordinance, addresses it specifically. This would include, to answer your question, Commissioner Field, we can't necessarily outright require. Your commission can't necessarily outright require a preferred source of power. However, during the CEQA analysis, it may be that solar is an appropriate mitigation, and that the CEQA determination may be better may be more acceptable, and the findings can be made by your commission if that mitigation is adopted over, say, for example, a fossil fuel machine or set of machines, or, but that would be project by project. So that would be something that would have to be looked at both during the analysis that CDD engages in with the applicant in the process of their application, and with your commission's review when it's finally brought to you.
Additionally, if I may, just bring it to the attention of the commission that at 12:30, I'm going to need to make sure that I give my staff a lunch break.
I just have a comment. It was mentioned earlier about the homeschooling. On the bottom of, mine says 29, but it says commercial cannabis cultivation exclusion areas. And on the second page, E talks about any public or private schools, grades K through 12. I think a point was, could we add homeschools to that? Was that?
That was the public
possibility?
input.
Pardon me?
That was the public input. So.
Right. I think the point that there's been a proliferation of homeschools since COVID, it might be something that we ought to consider.
You can certainly make that recommendation that the board consider it. Keep in mind that would come with, that we're at the very beginning of this process, that would come with an analysis at the legal and all of your recommendations.
Oh, of course.
That whether or not that's even legally feasible. If it is, then our office would advise both the staff, the commission, and the board on how certain preferred outcomes can be achieved. But at this stage, you can certainly make that recommendation to the board as a commission, if that's what the commission
I'd like it to be
chooses.
explored then.
At this moment, I'm looking for nodding or some establishment of consensus from the commission to add that to the list of stuff that I'm going to read back to you.
I don't agree with that consideration.
And I'm of the same. So that I'm not pushing for that.
My understanding is that homeschools are places where children gather, so that it's already covered.
It's not covered.
It's not legally covered. I mean, I think that was established in a previous
Yeah.
hearing that we had.
Okay. I find
So
it
if you want it to be
problematic.
considered, you can
It's problematic.
consensus with Sharon.
State law currently excludes education provided entirely within a private home from the definition of school. And the county's definition adopts the state's definition.
I have yet to understand if there's a consensus to add this to the list. I have 2 no's, but I don't necessarily have 3 yeses yet.
Look into that end of the table.
Commissioner.
I think that because in order to be a homeschool, you have to be certified by the state, that it's sort of it's a conundrum, a conflict. You can't be a bona fide homeschool unless you have met the criteria from the state. And so does that not then meet criteria for being, so it's a little confusing. That's all.
Whether or not one could interpret homeschool in any form to meet a definition of school at the state level, the state has actively excluded homeschooling from its definition for this purpose.
When you say this purpose, say more about that.
Cannabis cultivation?
Okay.
Setbacks.
And
We can
setbacks.
take a vote
Certain setbacks.
to recommend or not recommend this.
Okay, I'll make a motion. I recommend that we include homeschools as exclusionary areas.
You would add homeschools to the exclusion zone with public and private schools.
That.
As a recommendation from the Planning Commission.
To explore.
Do we have a second?
I'll second.
All in favor?
Aye.
Aye.
Aye. All opposed?
Aye.
Nay. And that motion passes with three ayes and 2 nays.
Thank you.
All right, moving on.
Yes, and so then the only other comments that I have is, one is that I would hope there was an attachment, well, there were several public comments. I would hope that, as it's been brought up a few times, which I don't know really to what level, in regard to public comment, I'm sorry, I'm hoping that public comment does get included as we move forward in this process with the Board of Supervisors. However, I would like to state along that line too, because I know that there were a couple of announcements at the very beginning of the meeting for us to forego this and reset this to another date. My personal feeling on this is that I'm really glad that we had this meeting. I'm glad that we had the opportunity to bring the Planning Commission into the loop on moving forward with the cannabis ordinance. Again, this is the summary at this point in time. So in the ordinance, the draft ordinance will be coming back around. I think the more opportunity, I consider this the Planning Commission meeting to be a public meeting, and the more opportunity that the public can have an opportunity to have say and contribute information is for the better. And so for that reason, I'm really glad that we had today's meeting so that we can get public opinion and public concerns addressed as we move forward with the project. Moving on, then the other thing is something we have not touched on, which is always an issue when the cannabis projects come before this board, is roads. And we do have in front of us here for the June 26th PC meeting, the County of Lake State and Local Minimum Fire Safe Regulation Guide. I'm very delighted that this is before us and will be on our agenda for June 26th, and look forward to discussing roads, and again, hope that becomes a topic of discussion as we move forward with towards the draft cannabis ordinance, because we do need to get that resolved. And to that end, I will, with former Supervisor Green here in the audience, I know he had said before, that we have, one of the issues that we have with cannabis is that we did move cannabis projects mainly out into rural, remote locations, which kind of causes this whole problem with the roads and also with the generators and other things. So we have some things that are good about it. On the one hand, having cannabis in remote locations kind of solves the odor problem, but it also brings up some other issues. So, and that's where we need to find some balance as we move
Commissioner
forward.
Rosenthal, if I could interrupt, I do know that Director Turner would like to have staff go on their lunch. So it is 12:30, and is it a 1 hour? Or?
Yes.
Okay. So we'll be back at 1:30 p.m. to continue with our meeting. And thank you very much.
Thank you.
So whoever's in the Zoom room.
Yeah, unless if we decide to open it. Check. All right, welcome back. We are back from our 1 hour break. It is 1:31, and we will continue with our meeting today. We left off at recommendations that we're voting on that we will send to the board. Is that correct?
Yeah, yes, actually, we were still going through attachments 1 and 2. I'm just checking to see if there's any further input from the Planning Commission. But just a little bit about next steps. Once the Planning Commission has completed their recommendations, I will integrate those recommendations into the staff report that then goes to the board on the cannabis summary. They will make their recommendations, and I will take all of that information to integrate into the draft ordinance. That draft ordinance will then follow the normal pathway for all of our land use ordinances. It will go through agency and stakeholder internal review. It will go through environmental analysis. Because it has land use related topics, it will go to the Ag Advisory Committee, it has agricultural related topics. After the Ag Advisory Committee, it will then go to back to this Planning Commission in a noticed public hearing, as well as after that then going to the Board of Supervisors in another noticed public hearing. Should the board make amendments or finally do adoption of that ordinance, it would then take 30 days to go into effect. So that's kind of the overall timeline for this project.
Thank you.
Can I ask a question also, or ask staff to, or ask the Director of Community Development to also kind of make a mention about any changes? I mean, because we've been operating for now a number of years under a cannabis ordinance. When the new cannabis ordinance goes into effect, what effect will that have on existing projects?
Thank you. Our current zoning code does have allowances for, or does have regulations for what's called a legal nonconforming use. Whenever zoning code changes and there are active use permits out there, they're considered legal nonconforming. So they can continue to operate using the regulations that were in place at their approval. They can't expand a legal nonconforming use. We have not had any of our use permits reach the end of their 10-year lifespan for cannabis use permits, but when it does happen, we will consider extending the use permit versus starting over with a brand new use permit. And so that legal nonconforming use is likely to continue in the future for those that have already been approved.
Mm-hmm.
But anything new going forward, including applications that have not yet been approved, would need to conform to the new regulations.
Thank you.
And I know that we were still going through attachments 1 and 2 for any further notes or concerns.
I was done with that.
Okay.
I mean, from my perspective.
Then if the chair would like to take public input, or I can give you a recap of the items that I have or interpreted as having established consensus.
Yeah, we can go ahead with the topics.
Sure. One moment. First point or recommendation, stronger language to encourage anchor points versus the concrete slab. And use concrete slabs only when anchor points are not an option and won't take away from prime egg soils. Second, seek additional options to mitigate odor impacts to residential uses.
Say that again, please.
Seek additional options. The Planning Commission offers its strong support of an existing bullet point recommendation to seek additional options to mitigate odor impacts to residential uses. Lots of typing, lots of typing. Next one, on the site reclamation bond, direct staff to see if we can increase this and based on what would be reasonable for a remediation of a site. As a side note, not necessarily a recommendation for the ordinance, but the Planning Commission is interested in seeing the county-wide map of approved and pending cannabis applications, which I'm taking that to mean that we'll just integrate that into our presentation when we have use permit applications before you. I was capturing synopsis of public input as well, so lots typing. Next, add homeschools to, or consider the addition of homeschools to the exclusion zone with public and private schools. And that is all I have as far as consensus reached recommendations from the Planning Commission.
Do we not have to reconsider farmland protection area?
Yes, we
FPZ?
did. Yes, we did. One moment, let me go back up to that. Thank you. Where are you? Another side note that I just saw bring a presentation on the hydrology report criteria when we have it ready. Oh, here we go. Thank you. Would like to see the board revisit FPZ boundaries. There was no official vote taken on that, but Commissioner Rosenthal made that motion and Commissioner Field seconded that. So I will add a notation for that one. Oh, and I also missed my understanding is the commission is fine with recommendations of revocations to go straight to the board unless the board has other ideas. Is that accurate? Great. Reclamation bond. Oh yeah, we already did that one, and I think that completes it. Did I miss anything else? Commissioner Field wanted to prohibit the removal of oaks, but I did not see any consensus reached after I informed the board that, or the commission, that we do have a parallel process right now regarding an oak preservation policy that would then apply to all of our projects. And I think that's it for me.
And then we talked about generators also. But I can't say what the consensus was on that.
I captured some discussion on generators.
Was the topic
I
of-
didn't see any consensus reached by the Planning Commission that was any different from what the task force had already recommended.
Yeah, because I believe that's a part of the conditions of approval for any project already, the use of generators.
Right, and the public input seemed to think that there was a recommendation to prohibit generators, and that is not the case. It's more to, the task force recommended that regulations for generators shall also apply to outdoor cultivation, and they should meet the fire code safety standards. We already have hazardous material storage, which would include fuel, under the jurisdiction of EH, and that has been frequently included as necessary in our conditions of approval.
Are there any other things that we might have missed from the commission? I believe that was everything. I would like to open public input into these recommendations. So state your first and last name, and you'll have 3 minutes.
Thank you, Chair. Tom Lasik. I just wanted to put a finer point on the homeschools so that there's clarity and context on that. So currently, homeschools are recognized by the state of California as a legitimate form of private school. Whether or not it's easier to get an affidavit for that is immaterial. That's codified, and you can look at Jonathan L. versus Superior Court of Los Angeles, 8808, to see the ruling on that. But to put it into context, in the Health and Safety Code, there are, I believe, 9 different areas where schools have a setback. If you want to put in a liquor store, a bar, a strip club, an adult club, a massage parlor, a tattoo parlor, a rehabilitation center, there's, I think, 9 of them. In each and every one of those cases, the setback is enjoyed by the homeschool. The only area in the state regulation where it isn't is with cannabis. So it's not that it's not a legitimate form of homeschool. It is. And in all those other cases, you don't see a flood of applications for homeschools to stop, a tobacco shop. It just doesn't happen. Okay, so I think for the idea of looking at health and safety for children, which is important, you can meet or exceed the state's requirement. And if it is determined through legal review that it does exceed a legal requirement, it should be considered. And then the last one is just a comment about the hydrology and whatnot. It is best practice to have some sort of independent review. The suggestion that I brought forward doesn't cost the applicant any more money, doesn't cost the county any more money. It's just a better way to do it that provides more transparency, and in an event, it should also help simplify the process. I personally know, having gone through several of these, not necessarily with hydrology, but also hydrology and others, there's a lot of things that should never have made it through because of what we know about the land and what was reported and things being magically disappearing, so on and so forth. Many of those things can be avoided if the process was different. Still needs to be done. There's several different ways to do it, and the best practice is to try to have it as independent as possible. We do that with inspections today. Like I tried to mention when I ran out of time, I don't get to inspect my own home. You guys come out. If you don't have enough inspectors, you get contractors for that. Looking at the land for archaeology, for biology, and all those other things is inspecting the land for suitability. And so in that same spirit, it should be recognized. Thank you.
Thank you for your comment. State your first and last name for the record, and you'll have 3 minutes.
Bill Wilson. I just want to go back to the odor. I think what the county probably needs to do is sort of decide the priorities. You know, are we concerned about the income or the health and the welfare of the people of the county? I have 4 peer reviews that show the exposure to unpleasant odors is associated with annoyance. It can cause strong associated with neurological, respiratory, and gastrointestinal symptoms. And I think what a gap that we have is that I think we need to address the scientific community, the regulators, and industry to measure the air quality in and around the cannabis facilities, and especially in open outdoor grow. I would be in favor of having all indoor filtered air scrubber facilities. And one of the reasons for that is because it's hard to measure because the influence of the formation of ultrafine particles and ground level ozone, it moves so fast, you need to have real-time sampling instruments, which Lake County does not have. They have no way of sampling the air odors. I have suggested there's a couple of instruments that are available to do that several other cities and states in the United States use. It gives a duration and dilution amount of odor to have something, but it has to be done. It can't be done a day or 2 days later. It has to be done in real time. That's going to protect the people in the community, and I think that it has definitely been proven that the VOCs, volatile organic compounds, are harmful to humans, they're harmful to the environment, they're harmful to vegetation. So again, we just need more testing and we need more attention to what the dangers are. Thank you.
Thank you for your comment.
Good afternoon, Chair and Commissioners. Margot Kambara. To piggyback on odor mitigation, there is no good technological solution for odor mitigation as far as cannabis is concerned. Increased setbacks have been recognized as an option. Municipalities that don't manage cannabis odor satisfactorily are finding themselves in court. It's best for all of us if we can come to an agreed solution. So we might not be able to find that solution today. We might not be able to find this solution when CDD comes forward with the revised ordinance. But as a community, it's a priority. We need to figure that out. On another subject, wildfire and generators. A lot has changed since the beginning of revising the ordinance. Since then, CAL FIRE has revised the wildfire hazard maps. And just this week, the Board of Supervisors approved those maps. Well, what does that mean? Well, just last month, the Board of Supervisors proclaimed May 2025 as Wildfire Community Preparedness Month. And that proclamation urges community members to do their part to get ready for wildfire. Great. We should do that. Now, with the adoption of those increased wildfire hazard maps, the county needs to do its part too to keep the community safe. And that means reviewing and reconsidering ordinances that put the community at risk, such as the use of generators for permits when the applicant is waiting for a hookup to PG&E that can take years. We're talking about projects that are up in highly graded areas, areas where there's a high grade, where it's terrible roads, one way in, one way out. It's putting those neighbors at risk. So we, as a community, should do our best to keep everybody safe, especially with discretionary use permits. Thank you.
Thank you for your comment. First and last name, and you have 3 minutes.
Thank you. Andrew Dobbs Kramer. Just want to address a few things here. Firstly, just want to clarify some of the misconceptions that might be proliferating here today regarding terpenes. They're actually not unique to cannabis. They're in anything that gives off smell. Your rosemary plant, your lavender plant, all of those have terpenes, and none of those have killed us. I think the idea that terpenes are something unique to cannabis that are causing some terrible crisis of ozone being created at the ground level has been disproven in numerous scientific papers. And I think this is just honestly not a good faith argument. If we want to say we're bothered by the odors, that's one thing to say, but saying that we're creating something that doesn't exist and has been disproven is a little bit out there. I also want to talk about, the beauty of the discretionary process is that as a planning commission and as the board of supervisors, you all are able to add conditions and mitigations, and staff is able to recommend mitigations that go above and beyond what would otherwise happen were there not a use permit at these properties. So in the case of generators, we're talking about a highly regulated application that says this is the generator I want to use, this is how it meets all the codes. And that being approved is far safer than just a random use of a generator up on a hill because it doesn't have a use permit and I'm just a private citizen and I can use a generator. So I think it's very important to consider that these aren't just, we're not just saying go start a generator wherever you see fit. These are very clearly delineated things in the use permits. These are standards that people are held to above and beyond what otherwise they would be held to for those. Also, I just want to talk broadly about the structure and about kind of the goal here to align with state law, which is the charge that the Board of Supervisors put forth for this endeavor. And currently there's a proposed regulation from the Department of Cannabis Control to strike energy reporting from the annual renewals. Not because energy reporting is not important, but because California already has the PUC and numerous other bodies. Every county has an air quality board. Those already regulate those things. There's no need to redundantly regulate them over and over and over again at multiple layers. These are exactly the burdens. These are exactly the compliance costs that are hampering the industry. Having to report the same thing to 4 different agencies, having to do the same thing 3 different ways because everybody wants it slightly differently. The board has asked for alignment with state law. State law is very clear about what you're allowed to do with generators and what you're not. Deciding that we need to write a one-off and reinvent the wheel here for every policy is not actually meeting the goal of aligning with state law and streamlining this for both staff and operators and improving legibility so that we really can weed out the bad actors. When everything is confusing, it's very hard to know who's working in good faith and who is not. Thank you.
Thank you for your comment. And I think he made some great points regarding legal activity and illegal activity, permitted and unpermitted projects, and just typical, use of anyone that wants to use a generator. So that's something that we have to keep in mind, that these applications are going through a lot of hoops to be able to get to where they are. So I think so it was a good point. Let me check the Zoom room to see if there's any hands. All right, I'm going to take some hands in the Zoom room.
There's a guest.
Thank you. My name's Angela Amaral. Once again, I'd like to request a recommendation that on that permit application, that for properties that are in an HOA and a POA, it be required that they submit a letter of approval from the HOA or the POA upon with their application. I know the county is not in the business of upholding HOA or POA law, but the county should not be undercutting an agreement between a property owner and an association at the same time. So it would be very helpful. This is a reason that I got involved in this over 3 years ago, was because our POA had an issue where applications were being submitted without approval from the POA, and it caused a big rift in our POA. So I would like to see that added as well. Thank you.
Thank you for your comment. We had another hand in the Zoom room.
Maria Khan.
Maria Khan, state your first and last name, and you'll have 3 minutes.
Oh, I'm sorry. I guess I never lowered my hand. I don't have a comment, but thank you all for being there and going through all this. It's tedious, and I appreciate what you do. Thank you.
Thank you. Is that it for the Zoom room?
Yes.
All right, so bring it back to the chambers, first and last name, and you'll have 3 minutes.
I need 2 minutes or less.
Okay.
Tom Lasik. I want to reinforce what the previous speakers talked about on the terpenes. It's absolutely correct that cannabis has terpenes, as does other fruits and vegetables that smell nice. They all have terpenes. It's a common natural odor. But that's not the point. The point is that there's another odor chemical called thiols. And thiols are the sulfur-based compounds. That's what gives you the smell of, well, as humans, we're evolved to avoid the smell of thiols. It's a smell of death. It's a smell of rotting carcasses, bad water, rotten egg smell. All those things that we've evolved to react to negatively. Cannabis is rich in thiols as well. That almost never gets discussed because it's not a good spin for the industry. But that's the smell that permeates long distances as well. It's not the terpenes. Terpenes do break down very quickly, especially with ozone types of features. But it's the thiols that causes the objectionable reaction, not the terpenes. So thank you.
Thank you for your comment.
Hey, Michael Green. I'm going to try to craft a compromise here. So going back to the homeschools, I know you already got consensus before lunch, at least, that you wanted to kick a recommendation to the board, but your consensus isn't here after lunch. So I just want to point out procedurally that any person who won on that motion does have the ability to enter a motion to reconsider or rescind the prior recommendation. And I'm going to ask that you do that for a couple of reasons. One, we don't know what we don't know. So in isolated incidents, maybe it wouldn't be a big deal. But if we have hundreds of homeschools, if not thousands of homeschools licensed in this county, where are they? And what would be the impact on the industry as a whole? How many projects could move forward? And without having a map of that, and by the way, good luck getting that map because homeschool locations are confidential and you can't get a map from LCOE. So you can ask him how many homeschools are in Lake County, but he won't be able to tell you where they are and comply with state law. So it seems like a overbroad fix to what may in many cases be an isolated problem. It is not the same as a K-12 school that has dozens, if not hundreds of students. It is not the same as a youth center or a church gathering hall. And the reason those definitions are stacked up in state law in terms of cannabis licensing is because those greater numbers of children are where the focus of the protection of the public safety and welfare is, not these isolated incidents which are more residential in nature. So the compromise I'm going to propose is, I actually agree with Margot and others who have noted that sometimes, especially in the case of setbacks from off-site property, residential properties, that maybe that 600 feet, that 800 feet, that 1,000 feet, whatever it is, and I'd have to defer to staff at this point, just may not be adequate. And on the one hand, I want to fight for the right of agricultural odors to be treated that way and for people to just get over it. In the real life, that's not real life, so it should be treated the same as a sheep farm or a hog farm that has nuisance odors. They're agricultural odors, and we should not try to overregulate those to the point that we hamper agriculture. But we also have to understand over the history of our cannabis industry up to this point and where we may be moving in the forward. Odors and odor control. Distance is where it's the cheapest, most effective way. So if I could try to talk you down off the ledge of the home schools and say what you really want to do is protect the off-site residences and consider whether greater setbacks would actually help that, as opposed to other types of things that would have unpredictable consequences. I think you'll see broad consensus in the room that we should at least ask staff to take a look at those setbacks, especially in concerns for off-site residences, and see if there's something we can do there.
Thank you for your comment. Are there any further comments in the Zoom room or no more in the chambers? So we will close public input and bring it back.
Oh, he put his hand up.
Oh, okay, so we'll still closing public input, bringing it back to the commission for further discussion.
One thing I'd like to say is thanks very much to everyone who's here in person and on Zoom, offering comment on this subject matter. I also want to thank those who have sent in green sheets. One item on a green sheet that we didn't discuss is scenic corridors. So I just wanted to bring that up, as I think that's an important issue, not only for this topic, but just all. And I'm going to relate back to now out of business, and now I believe it's a cannabis operation, actually, at what was formerly the Parker Plastics on Highway 29 in Lower Lake. And I remember when they did an expansion and put in a building, that they had a large building that was going to, just have a blank wall against Highway 29. That was one of the things that we looked at, is how can we mitigate that and make that softer so that it didn't impact the scenic corridor. So I know that there has been a past project, or a more recent past project, that also kind of touched on that scenic corridor issue. And so I guess I just wanted to bring this subject matter up in beautiful Lake County here, that is an issue also that we want to just be sensitive to. And perhaps there's already verbiage in the ordinance that protects scenic corridors, but nonetheless, reading through it in the public comment that we received, I just wanted to make that comment. Thank you.
Thank you for your comment. All right, well, seeing as we have these recommendations are from the Planning Commission, do we have to make a motion to?
It's up, if you would prefer a motion to approve those recommendations as I read them, that's fine. Otherwise, I have consensus, I have direction.
Okay, or do we have to go one by one, like as to approve them? Okay. Well, regarding the homeschooling, the consideration to add homeschools to private or public, or to have the same protections as private or public, since that did come up in the public input, do we have to reconsider that? No? Okay.
No.
All right.
No, but I do appreciate the compromise that was offered with the setbacks, and that has been recorded or entered into evidence, I guess. And
Yeah, the compromise offered regarding just relooking at setbacks to offsite residences may help, because I was wondering if homeschools are confidential in nature and we can't find out during our completeness review initially, until it conceivably would not, the neighboring homeschool may not become aware until the permit process is going through a notice of public hearing and they receive a public hearing notice. That's very late in the process. So if there is not an easy, or not just easy, but pathway for staff to determine homeschools, that could be problematic.
yeah, that definitely wouldn't be in line with streamlining the process. So,
Right.
But anyway, so that is an option, I think, for consideration as that discussion moves forward.
I just think we just ought to explore all the possibilities, setbacks included. You know, let's look at it in its entirety, and then we can make an informed decision of what might be the best way to accommodate as many of those involved as possible.
That's fine. When these recommendations do go before the board, after that, during that internal drafting of the ordinance process, I'll be working with staff as well as county council to take a look at what we are able to do. And if we need to consider other options at that time, I'd be happy to bring that back to the commission.
Okay.
Yeah, I guess I'd just like to note that the most discussed topic in these recommendations was the odor control. So just I'm looking forward to see how that goes, and like I said, hopefully we can mitigate and find ways to mitigate that issue.
Certainly.
So I don't see that we have to make any motions for this item.
Staff, we have received direction.
Okay. So that concludes our non-timed item 7A. We move on to our item number 8 for department update.
I have no department update today.
All right, no department update, which leads us to this meeting is adjourned at 2:05. Thank you.